Further hearing in the appeal, Holland against Commissioners for Her Majesty's Revenue and Customs.
Mr. Knox, before you begin, could I mention that we've been examining Rule 25?
Yes.
The point that Mr. Green raised. And we've decided that you can argue all your points insofar as they might cause a problem under Rule 25, that is, the any essay. But we think it's simpler that you just simply put them forward since they've been focused in your written case. And at least we don't feel that Mr. Green is going to be disadvantaged. Thank you very much.
I was glad to. My Lords, yesterday I finished with some passages from Salomon and Salomon, in particular from Lord Halsbury's and Lord Herschel's speeches. My Lord, I don't propose to go to any other speeches for the moment. I'm conscious of the time. Can I just say what I get out of those speeches? First, of course, one must recognise the separate legal personality of the company from both its shareholders and indeed its organs, that is to say, its directors. It's a fiction, but the law, as it were, must recognise that fiction as a reality. And that has important consequences. The first is that, as is common ground, it was paycheck directors, in this case, who declared the said to be unlawful dividends. Secondly, all Mr. and indeed Mrs. Holland were doing, as the board of paycheck directors in declaring those dividends, were acting as the appropriate organ of paycheck directors in causing it so to act. Thirdly, my lords, this is really the crucial point, the direct fiduciary and common law duties of a director towards the composite companies were owed by paycheck directors to the composite companies. There was no direct fiduciary or common law duty on the members of the board, Mr. Holland, in causing paycheck directors so to act. And there is no need in law to impose any such direct duty, direct fiduciary and common law duty upon Mr. Holland, or indeed Mrs. Holland, in relation to the declaration of dividends, as long as they were acting as the appropriate organ of paycheck directors.
You mean by the phrase no need?
Well, no need, indeed wrong. I would submit there is no lacuna in the law. And it's not as if the law has to say someone did this and it must therefore be Mr. and Mrs. Holland, or there must be some responsibility and it must lie with Mr. and Mrs. Holland. I say that is wrong. There is no gap in the chain of duties. My lords, whatever liabilities Mr. and Mrs. Holland may have had in relation to the declarations of these dividends would only be secondary liabilities. That is to say, for procuring a breach of trust, but that wouldn't give rise to a liability or direct liability as de facto director, for procuring a breach of fiduciary duty, or indeed, perhaps, for procuring deliberately procuring a breach of the equitable and common law duty of care by paycheck directors. Each of those would be a secondary liability, but there would be no direct fiduciary duty and therefore no breach of any direct.
So are you saying that on that approach it's outside the reach of Section 212?
Absolutely, my lords, yes, absolutely. Not even the case put against us. It's not pleaded against my clients that we knowingly procured, or whatever the mental element would be, and it would be very important, that we knowingly procured a breach of fiduciary duty by paycheck directors, or a breach of trust, or a breach of common law or equitable duty of care, or indeed, my lords, an idea floated yesterday, a sort of knowing procurement of a breach of statutory duties, which would give rise to interesting questions of law as to what is the mental element required for, or none of this is an issue in the case. The case has been put against us on a straight breach for direct duty. And that, I submit, is a very important point. And that's why I say this is what follows from Salomon. And my lords, this theme between the difference between a direct fiduciary and common law duty on the one hand, and which gives rise to a direct primary liability, and on the other hand, a potential secondary liability, is at the heart of my submissions. And I'll be coming back to it later. And I say what the revenue is really trying to do in this case is by the de facto director route impose upon my client what is in truth and could in truth only be imposed by way of a secondary liability claim or accessory liability claim. That's the point I make. My lords, just while I'm on the Salomon point, and I'm still on, as it were, my first argument, namely the revenues argument ignores the scheme of the Companies Act. Mr. Green says, but look at section 309A, I think, of the 1985 Act, which effectively prevents directors contracting out of their liabilities to a company. He says, but look, Mr. Holland he set up this structure precisely in order to enable himself not to have a personal liability, qua director of the composite companies. So, the suggestion is that Mr. Holland was, so to speak, using this scheme for a forbidden purpose. My lords, I submit the following on that. First of all, it begs the question. Mr. Holland was entitled, under the Companies Act, to make a choice. Mr. and Mrs. Holland and their advisors were entitled to make a choice as to who the director should be. Mr. and Mrs. Holland, on the one hand, alternatively, should it be paycheck directors. They were perfectly entitled to make that choice for whatever reasons they liked. As long as they had no fraudulent intent in mind, which of course would be very different, they were entitled to make the choice they made. Secondly, I submit that the Companies Act does not prohibit someone in Mr. and Mrs. Holland's position from going through the thought process that they did and setting up paycheck directors as the director rather than themselves taking on the liabilities. Nothing in the Companies Act says, well, you can't do that. And my lords will recall the passages I took you to yesterday from Salomon and Salomon, where it was said, well, it may be that if the draftsmen had thought about this problem, they wouldn't have allowed it. But that's no reason now for the courts to say, well, the draftsman should have thought about it, and we're now going to say it's a forbidden purpose, and therefore we're somehow going to impose a direct, de facto director liability, when otherwise we would not have done. The courts can't do that. Thirdly, my lords, and I submit this is an answer, Mr. Holland, but first of all, paycheck directors has an unlimited liability to the composite companies, and Mr. Holland, in turn, has an unlimited liability to paycheck directors. So, my lords, I submit there's nothing inconsistent, if you like, with the purpose of section 309 in the scheme that's been set up. It's allowed by the Companies Act.
Do you quarrel with Lord Justice Rymer's paragraph 74? I'm just trying to understand how far your submission goes. I follow the argument based on Salomon, but he emphasises in that paragraph at the end of this chapter of his discussion that nothing that he said is intended to suggest there can never be circumstances in which a director of a corporate director can or will act so as to regard himself as de facto. So, are you saying that this is an absolute position and therefore he's wrong?
I submit he's absolutely right. I endorse everything he says, without more. My lords, the more might be, supposing what happens is Mr. Holland, without the authority of the board, and this is what Mr. Justice Millett was talking about in Hydrogram, without the authority of the board, Mr. Holland individually and personally starts giving instructions to the composite companies. Now, in those circumstances, what would be said is, well, look, only the board has authority to make decisions in relation to only the board of paycheck directors can make decisions in relation to the composite companies. Here you are, on a frolic of your own, you haven't got the consent of the board, there's no board resolution authorising this, you've gone and meddled in the affairs of the composite companies without the board's consent. Now, in those circumstances, you would be in the position of, just like a trustee dissenter, you would be someone meddling in the affairs of the company in this case without a proper appointment.
So if A is an individual director but always acts on the instructions of B, another individual, B would be a de facto director.
Well, might be a shadow director.
Yes.
That would be the classic shadow director
Yes.
case, wouldn't it?
Yes, that would be a shadow director situation. Query whether it would be a de facto situation. Now, my learned friend, I think, disavowed any case in relation to section 212, at least, that situation would constitute shadow directorship comes within section 212. But, my lords, what I would submit is to that, one comes to it with Hydrodam. Even in Hydrodam, Mr. Justice Millett said that the directors of Eagle, if Eagle Trust had, as it were, meddled in the affairs of the underlying company, then Eagle Trust would be the shadow director, but not the directors of Eagle Trust who caused it so to act. And that's because they would be acting as the appropriate organs of Eagle Trust. And therefore you cannot say that the instructions were being given by them personally rather than by Eagle Trust. And also I think that's the implicit analysis in Hydrodam. But, my lords, I take your point about shadow directorship, but I submit that is not this case. We're not in a shadow directorship case. So that issue doesn't arise. My lords, if the shadow directorship point did arise, then it would practically always be the case. So one would imagine a corporate director very often, one would look at the board of the corporate directors and say, well, the board of the corporate directors must be the shadow director behind the corporate director. Because, of course, the corporate director is accustomed to act on, and in one sense, on the instructions of its board. It can't act otherwise on the instructions of its board. So, my lord, that I submit is the answer to the shadow. There are two answers built in there. One, shadow directorship doesn't arise, but B, it could, even if it was argued, it would be wrong.
Well, I mean, paragraph 74 is not talking about shadow.
That's a fact.
Yes.
My lords, I've given you an example of the more. It's the director who steps outside his authority, which he has from the company, and starts meddling in the affairs of the underlying company.
But are you suggesting that there were board meetings of paycheck directors?
Well, my lords, there were. I mean, both Mr. and Mrs. Holland were present. But, my lords, this point wasn't really gone into in the evidence, and it's noted by it was noted by Mr. Corson, QC, in his judgment, and he notes that there were automated board minutes. My lords,
but he does use the word purported, doesn't he? Which I imagine you don't much care for. I mean, in paragraph 24
yes.
of his judgment. And that's the total of his findings on that, is it?
Well, my lords, I think it is. And I think, my lords, he does also note that the point wasn't pursued. And I note this, if I can just dig up my reference, my lord. I think if one looks at this page, I've got a note of paragraph 195 the judge's judgment.
Of the trial judge.
Paragraph 195 of the trial judge, page 103, tab behind flag 4 of the four bundles.
Well, so he's not prepared to say it was outside the terms of the articles.
Yes. Well,
but it's still a question as to what he's really saying in paragraph 24, isn't there?
my lords.
And
no.
a sole director has authority in paragraph 25.
Well, my lords, I think the trouble is, paragraph 195, he does say it didn't form part of HMRC's pleaded case. There was no investigation of the issue at trial.
Is there any evidence of a meeting?
Well, my lords, I think it was put in cross-examination, and the evidence was that Mr. and Mr. Holland were in the same room when the figures were put into the computer.
Every time?
Well, I think that was the general. I'm speaking from recollection now.
Yes.
That was the general, as it were, because they worked in the same room. That was what the generally happened. But, my lords, there wasn't. The point is, this issue wasn't investigated as such a trial. It wasn't pleaded as an issue against my clients. And I would also submit that It wasn't suggested either that Mrs. Holland didn't know of or approve of the dividends. My lords, that one can see, if as well one board member does something without the other's knowledge and consent, then one can see the point. If in fact what has happened is one director has done something with the other's knowledge and consent, my lords, then in my submission the point doesn't arise. And certainly, my lords, there was absolutely no suggestion that Mrs. Holland didn't know what was going on. And my lords, the evidence was it was Mrs. Holland who actually made the payments of the dividends by signing the relevant documents on the backs payments.
Do we have a finding to that effect?
My lords,
I don't recall that.
I'm not sure if it's a finding. It may be, but my lords, that certainly was the evidence.
I don't know which way it goes, and I don't have a view, but of course it's absolutely everyday experience that board minutes are produced in cases where there was no actual board meeting.
Well,
Not necessarily dishonestly. In fact, in 99% of the cases, it won't be dishonest.
Well, my lords, exactly. My lords, in my submission, the crucial question is whether or not, strictly speaking, the board minutes recall a board meeting. The question is, did the directors, as it were, those who had the running of the company, did they all consent to this particular act? And if they did, my lords, then it cannot be said of the one that he was acting outside his authority when he did that act.
Well, I think you're saying, if I understand you correctly, that it's never been suggested that Mr. Holland is liable because there was some failure to comply with company rules and regulations, articles of association and so on, in relation to board meetings or minutes.
Absolutely, my lords.
What he said against you is much broader than that. And as I understand it, I'll be correct if I'm wrong, is that it doesn't matter. There are perfectly proper board minutes, meetings, whatever you like. Mr. Holland still remains a de facto director of the company in question, the subject company, for the reasons that have been suggested.
Oh, yes, well, my lords, that's the big point against me. I'm simply dealing with the point, well, you know, were in fact, was Mr. Holland acting within his authority? And in my submission, he was, and it's accepted he was. It's not being said, because if he wasn't, these acts are not the acts of paycheck directors.
Well, I mean, he has the benefit of Article 12B,
yes.
which, I mean, perfectly above board for him to do this as acting as a single director, because he has the authority to do it under the article.
Yes. My lords, that's why I say this point wasn't invested. I mean, my lords, I think there's another article, Article 70 of Table A, from recollection, which entitles the Board of Directors to delegate to one director any decision it likes. So, my lords, there would be a number of answers to this point had it been a live point at trial. Sorry, it's 72, I'm told. It's Article 72 of Table A.
And that's incorporated into the articles.
Which is incorporated into the articles, yes. My lords, the reference which Mr. Case has drawn to my attention, the reference I was thinking of is paragraph 234.1 on page 115 of the judge's judgment, where he finds that Mrs. Holland processed the transactions that led to the payment of dividends in a role that was clerical.
But no evidence she participated in the decisions.
Yes, but the point I was saying, she knew about it. There was no suggestion at all that Mrs. Holland had no idea of what was going on.
Yeah, I mean, I think he describes her position in paragraphs 180 onwards.
Yes.
Where he's considering whether she was a de facto director.
Yes. But my lords, what I submit follows. What I submit follows is that as Mr. Holland was at all times acting in good faith and within his authority as a director of paycheck directors, it was paycheck directors who authorised the payment of dividends, and therefore there is in room, I say there's simply no room in law absent some extra factor, for saying that Mr. Holland himself concurrently became a de facto director. There must be something more than merely acting within your powers as a director of the corporate director. Something more. And there is no more in this case. And I adopt entirely, my Lord's paragraph 74 of Lord Justice Rymer's judgment. There must be something more. And there was no more. And then all that really follows from Salomon. My Lords, if the revenues argument is right, it comes to this. There is always at least one individual director on whom liability can be placed. And my Lords, the revenue goes that far. There must be. You can always look through the corporate veil to find the chap who made the relevant decision, or chaps, or the man and the lady.
Well, I think you'd say it necessarily has to be so. If you've got a corporate director, you've got to have some human being who's made the decision,
yes.
Or human beings.
A human being. You've got to find some human beings. So that the revenues case is that there is always that you can always identify a human being in any case. The court will always be able to do so. Now, my Lords,
It's not an unreasonable attitude, is it?
My Lords, if one was passing a law, my Lords, of course, my Lords, I'm not here, if I may say, as I was speaking in Parliament, saying what a good law or bad law would be. I'm simply saying what is the law. And this is why I've emphasised the structure of the Companies Act. My Lords, if it was open to you to make policy, my Lords, I couldn't argue that it would be a very bad policy.
Well, we only have one question to answer, don't we?
Yeah.
Don't we? Was Mr. Holland a de facto director?
Yes.
The de facto director being a recognised individual known to the law, and there's a good deal of law about what amounts to a de facto director, and that's the point we're on.
Yes, but my Lords, there are policy questions involved.
And if he is a de facto director, then Salomon and Salomon is neither here nor there.
No, but it's relevant to... my Lord, you have my submission. It is relevant to that question. My Lords, I
You
accept...
say that if the revenue is right, there will always be a
Yes.
de facto director if there's a corporate director,
Yes.
a sole corporate director.
My Lords, that's the consequence of the revenues argument. And I submit if that had been the intention, or if that had been in the thoughts of the draftsman of the 1985 Companies Act, and he had wanted to ensure that corporate directors couldn't be used in the way that Mr. Holland and Mr. and Mrs. Holland have sought to use them, one would have thought that it would prohibit corporate directors altogether. Because that way you've got to have individual directors on whom liability can be fixed.
You could also perhaps say that if that position is right, the discussion that preceded the latest Companies Act was really rather beside the point. The discussion being, well, would it be a good idea to abolish corporate directors altogether? Because the answer would be, well, it doesn't matter, because you can always go behind them.
Yes, exactly.
But that doesn't seem to be what the legislature did. They sort of produced a compromise whereby you had to have at least one human being.
Yes. And my Lords, the reason I've taken it back to 1908 is successive legislatures have quite happily passed laws which said a corporate director can be the only director of a company. My Lords,
Could I just
Yes.
go back on the suggestion that you would always have a de facto director in that situation? Imagine a corporate director that has a board of half a dozen people who are not related, have other jobs and directorships, and they meet once a month to consider the agenda for the board meeting.
Yes.
And they then have paid employees of the corporate director who then carry out the collective decisions of the board. That wouldn't be a situation of de facto directorship for any of those six individuals, would it?
well, my Lords, if, as I understand Mr. Green's argument, there would always have to be someone who'd be responsible.
No, you've always got to find human beings, but it doesn't mean those human beings are always going to be de facto directors.
Well, as I understand it, Mr. Green's argument is there will be one or more human beings who are de facto directors because they have participated actively in the board meeting.
If the corporate director acts as a director for the subject company, whether it's approving dividends or doing anything else that a director can properly do.
Yes.
Some human being behind that corporate director has decided that is what should be done.
Yes. My lords, take payment of dividends, for instance. There's got to be a meeting, let us say, someone has got to pass the resolution to pay the dividends, and someone's got to actively participate in that meeting and say, yes, I think we should pay dividends.
Well, the special feature of this case, and this is how the whole thing was set up, is what one finds in Article 12. It's maybe helpful to look in the bundle Part 2 just to see it all set out. It's page 108 with the numbering at the bottom of the page, and this is where the shoe pinches, perhaps. The structure was designed by way of innovation on Table A.
Yes.
By putting in Article 12, and I can't remember what Regulation 64 of Table A is, that's excluded.
Yes.
And then you've got 12B, this is at page 108, you've got this particular one about the maximum numbers and so on. Whatsoever the minimum number of directors shall be, a sole director shall have the authority to exercise all the powers and discretions by Table A. So the paycheck directors and paycheck secretarial, for what it's worth, were both set up. I think this may be the secretarial example, but it's the same, I think, in both. Set up on the basis that one single director would be able to do this. So, like Lord Walker, I have difficulty where you have a multiple lot of directors who all meet together. That's the Table A situation, I suspect, whereas here we've got this particular one which enables the controlling mind to actually control everything the company does because he's got authority under the articles to do it.
Well, my lords, I think these articles, in fact, are one of the composite companies rather than the...
Oh, are they? I beg your pardon.
So, yes, if you go back to page 105.
Yeah, well, I'm looking there because I'm assuming that's what the trial judge refers to when he refers to 12B in his judgment.
My lords, I suspect, although I'm not sure, that the articles of paycheck directors are the same.
Well, would it be wise if somebody could check that for us? Because I couldn't find it in the bundle, and I was using this as the best guide I could to what is set out. But it would be helpful. You're absolutely right about this. But the point I'm really making is that we're dealing here with a very highly specialised structure, which, quite understandably, of course, because there's no suggestion there's any sort of devious feature behind it, but Mr. Holland was obtaining a structure which enabled him to, in effect, run the companies.
Well, my lords, the structure, there was another element of the structure, which was Paycheck Services Limited, who provided the administrative services to the composite companies. So Paycheck Directors provide, so to speak, the directorial services.
Yes.
Paycheck Services Limited does all the administration.
Yes.
Paycheck Secretarial as well as the secretarial work. But Paycheck Director's role is simply acting as director. And so all Mr. Holland, Mr. and Mrs. Holland do in their capacities for Paycheck Directors is act as directors and pass the board resolutions. There's not much else for them to do qua directors of Paycheck Directors. Because Paycheck Directors doesn't have any other role except that.
No.
Paycheck Services Limited does all the administration stuff.
Yes.
Now, that's irrelevant to the de facto directorship point.
And the composite companies, of course, are very active in performing their particular functions.
And the employee, effectively, the shareholders are the employees, and they have their labour subcontracted out to the third parties, yes. But the person who will deal with the third parties is Paycheck Services Limited, administering the contracts and so forth. My lords, just go back to what I say. If it had been the intention of the 1985 Act to have the result that Mr. Green seeks, it would have prohibited the corporate directors, or it would have provided that there must be a single human director, or it would have suggested or provided that where there was a corporate and only a corporate director, then human directors of the corporate director would have to be liable by way of guarantors or indemnifiers.
I'm sorry, could I just trying to understand how this worked in practice? So it was Paycheck Services which billed the clients, was it?
It would have been in the composite companies who would have billed.
Well, that's what I'm getting at,
Yes.
because you referred to it as the trading company, but
No.
so the composite companies billed the clients,
Yes.
and they then paid a fee up to Paycheck Services,
Yes, because Paycheck Services would do all the paperwork. So
which is why it's referred to as a trading company, as well as being the holding company of Paycheck Directors and Paycheck Secretarial.
yes.
And so the composite, so all the bills went out from the composite company.
My lords, I'm pretty sure.
It may not matter, but I'm just trying to understand how
My lords,
it worked.
Yes, because it would have been the composite companies who, strictly speaking, were providing the services to the third parties.
Yes.
As it were, it would say, Mr.
Well, not strictly speaking. I mean, that was
In law, it was.
the substance of the matter, wasn't it?
Yes. Yes. But, my lords, I think that's how it worked.
Thank you.
My lords, so I've made my submission on the scheme of the Act. And I said, why? You would have expected the Companies Act not to be drafted in the way it is if Mr. Green's arguments are right. And certainly, I submit, there's nothing in the scheme of the Act which means that you should impose a direct fiduciary duty in these circumstances. There's nothing in the Act that leads to that conclusion, that it would be right to do so. My lords, the second objection I have, my lords, I want to emphasise this. It's made in my case, but I submit it's the heart of it. It is at the heart of this case that the revenue, I submit, misstates the rationale behind the doctrine of de facto directorship. It is not, in my submission, a flexible tool, to use Mr. Green's phrase, developed in order to catch human beings who operate a corporate director, regardless of their capacity, the capacity in which they act, or their good faith. Rather, it is the application of a well-established rule in the law of trusts and wills which fixes liability on a person who, without a proper appointment, assumes the function of a trustee or executive. And it transfers that doctrine over into the law relating to companies and its directors. And the essence, therefore, of a de facto director is that he is someone who has, in the 19th century language, usurped the role of the de jure directors and is a director in his own wrong. And that's exactly how it was described in the 19th century cases. One of them, so.
Could you repeat that? Director in his own
Director in his own wrong.
In his own wrong.
Yes. And my lords, that colourful 19th century language is reflected even in the 20th century language, which talk of de facto director being someone who assumes the role of director. But
There are hundreds of cases in the United States to the same effect.
well, I didn't know that, my lord, but yes. That's the essence of it, is you do something, you assume a role without a proper appointment. And what the doctrine is this. You can't come along. If having assumed that role, you, let's say, commit a breach of trust or whatever, and you're then charged with the breach of trust, you can't then say, well, I know if I had been properly appointed, it would have been a breach of trust, but as it happens, I wasn't properly appointed, and therefore I can't be liable for a breach of trust. And that's what the doctrine is to stop someone relying upon the absence of his valid appointment and putting that up as a defence to a claim for a breach of trust or a breach of fiduciary duty or whatever.
He could have a perfectly valid appointment at another level, of course.
Yes.
I mean, the fact that he's appointed for something else, it doesn't matter, I suppose, on your theory. I mean, the background facts can vary considerably from one case to another.
Yes. But my lords, that's always, and so it's the essence of it is to stop someone relying upon the absence of a lawful title to do what he's done. If he can say, oh no, I should say, I did this as a consultant to one of the shareholders, let's say, and I was perfectly entitled to do that as a consultant to the shareholder, then the doctrine has no application at all. He's done what he's entitled to do by virtue of his consultancy to the shareholder. And there's no room for saying, but you've also usurped the role of the directors. He says, no, I haven't. I've simply done what I was entitled to do, and on this hypothesis the shareholder is entitled to do, in giving certain advice or giving certain directions. My Lords, if I can go back to the 19th century case, which I wanted to rely on, and then I want to go to a 20th century case, 21st century case, which I submit explains in slightly different language, but explains the doctrine very clearly. The first is a case of Gibson, and a judgment in particular of Mr. Justice Blackburn. And the second is the case of Dubai Aluminium and the judgment of Lord Millet. And the Gibson case is at file 2, 14, tab 14. And my Lords, in this case, you can pick it up from the third paragraph in the head note at 329. Fourth. The appellant was the secretary of a company registered under the Companies Act. Articles of Association did not provide for the appointment of a manager, and none had been appointed. At a meeting of directors in 1872, the appellant reported that he'd called a general meeting with shareholders, and in 1874 he had, in a letter to the directors, stated that unless certain contracts were carried out, he should feel it his duty to summon a general meeting of the shareholders. No ordinary general meeting of the shareholders had been held in the year of 1873, and no list of shareholders had been forwarded to the registrar in compliance with section 26, and the appellant had not taken any steps to cause a meeting to be held in 1873. He was convicted on an information of charging him as manager with authorising a default in forwarding a copy of the list of shareholders to the registrar in 1873. Held, the conviction ought to be affirmed. There was evidence that the appellant was manager de facto, and therefore a manager within section 26 of the relevant statute. As he took no steps in 1873 to call a meeting, thereby made it impossible for him to forward to the registrar a list of members, there was evidence that he knowingly and willfully authorised a default within section 27. And can I just mention one point which I think is interesting in this case? Here is a de facto manager being charged with not doing something. And I submit this is how the doctrine works. It has nothing to do with whether you've done something or not done something. It's whether, by virtue of the office you have already assumed, you have brought yourself under the direct fiduciary and common law duties. If you have, you're as guilty for an omission as you are for a commission. And this is, my Lords, you can see the significance of that because Mr. Green relies upon the active-passive dichotomy. I say it has nothing to do with de facto directorship. Now, my Lords, one can move on in this judgment in this case, to paragraph, to Mr. Justice Blackburn's judgment on page 336. The second paragraph, just the first 5 lines, and then I want to move on to another passage. The first question raised is whether there was evidence on which we could find as a fact that the appellant was manager of the company. That involves 2 things. Whether there was evidence that the appellant was manager in any sense, and whether the sense in which he is shown to be a manager is a sense that would make him liable to a penalty under section 27. And he carries on, I'm of opinion that in both respects the Mayor was right. My Lords, there's then a discussion about section 27, which I don't need to take you to, but one then goes over to page 337, 6 lines from the end, after the discussion about section 27. In the present case, the appellant is not a manager appointed in that way, so we haven't got a proper appointment. The evidence comes to no more than this, that he was permitted by the board of directors to manage the company generally, just as if he had been legally appointed by them to act as manager. I think there is evidence that the appellant took upon himself to act, and did act, just as if he was such a manager. The question, therefore, is whether a person is thus a manager de son tour, a manager in his own wrong, whether he can protect himself from liability cast upon a manager under section 27 by saying, I am not a manager de jure. I think he cannot. There are many instances in which a person who de facto exercises an office cannot defend himself by saying, when he's called upon to bear liability in consequence of his wrong, I am not rightfully in the office, there is another man who may turn me out. An executor de Santor is an instance in which a man incurs all the liabilities of an executor as to third persons, and he is not permitted to say, I am not an executor. There is another man who may take out probate. The answer is, your liability as to third person rests upon your being executor de Santor. You have usurped the office and must bear the liabilities. And then Mr. Justice Blackburn goes on to give an example in relation to decisor in old times, who turned out the rightful owner of the land, and so on. And my lords, dropping to halfway down this page 338, so if a director were to set up in answer to a penalty under section 27 that he was not a director, that he was illegally elected, the answer would be, you've acted as a director, and were a director in your own wrong. I think there was evidence to justify the Lord Mayor in drawing the conclusion that the appellant was de facto manager. And then, my lords, the important passage. No doubt the appellant is called secretary, but he was a person to whom the whole management had been delegated, probably improperly delegated by the Board of Managers, and who had taken upon himself to act as sole manager. He himself says in the minutes, the secretary, that was himself, reported that in order to comply with the requirement and so on, he had called a general meeting of the shareholders. That is evidence upon which the Lord Mayor might find that he had taken on himself the management of the company. He has of his own authority done an act which was to be done only by directors. In other words, he couldn't do it as a secretary. That's crucial. So again in the letter, he tells the directors he'll call a meeting. I don't say he had power to call a meeting. I think he had not, but I think that is evidence that he had assumed to act for the directors and had taken on the management for himself. My lords, the reason I submit this is so significant is what is being said here is he did have a role in the company, he was the secretary, but he'd gone beyond the powers of a secretary in doing what he did. Therefore, he was a de facto manager. If, in fact, all he had done was do things which he was entitled to do qua secretary, there'd have been no question of saying he was a de facto manager. My lords, to similar effect is the judgment of Mr. Justice Lush, page 341. And in the second paragraph, about 5 lines down, he says, in the letter of the 13th of January, in which he complains of the directors not having gone on, according to his view, in the purchase of contracts and patents, he says, I am anxious to be relieved from my present position, and desirous to remain only so long as may be necessary to complete this contract, and unless these are carried out in a business shape, I shall feel it my duty to summon a general meeting. How could there have been any duty in him, or how could he have had the power to call a general meeting of the shareholders, except in the capacity of a person acting as manager of the company? I think, therefore, there was evidence, and so on. So, my lords, that is what I submit is the doctrine. My lords, I should say Mr. Justice Quain disagreed in the result because he said that on the proper construction of the relevant act, it didn't catch de facto managers.
Manager meant properly appointed manager.
Yes. But there was no disagreement on the general principle set out in those two judgments. Now, my lords, that's the principle of what I call usurpation, the fundamental notion of a de facto director. He's assumed an office without a proper appointment, and he's not to be heard to say, I didn't have a proper appointment, as a defence to some claim against him. My lords,
just pausing there, I'm just checking again against paragraph 74. I don't think that's what Lord Justice Rymer was really thinking of. He's not really looking at somebody who doesn't have a proper appointment when he's saying that he's not excluding the possibility of somebody who is a director of a corporate director being held to be de facto.
my lords, I certainly refer to this case in the Court of Appeal, and he does refer to it himself for apparent approval in his judgment. I can't remember now where, but he does mention this case. And my lords, I submit, it's certainly not inconsistent with what he says. Namely, that the essence of it is the essence of a de facto notion is the to act without a proper appointment. My lords,
did you say all the cases are consistent with that, all the more recent ones?
Yes.
I was just thinking of Richborough, where I think it's not. It simply refers to a person directing the affairs of the company.
But in Richborough also, I think it's Timothy Lloyd's decision where he talks about you should give the benefit of the doubt if the acts could be referable to this, so that said de facto directors acts being referable to his position as consultant to one of the shareholders, which implicitly, I submit, goes to the same point, namely, if he can say he's got a lawful title to do what he did, then you don't fix on him this direct duty. My lords, I submit there is no case that is inconsistent with this at all. This is the doctrine of de facto directorship or de facto trustees or what have you. And my lords, that, I submit, is apparent from the Dubai aluminium case, which is in the same bundle, I think, at tab 12. And my lords, this was a case about liability of partners, but that led to a discussion in Lord Millett's speech about what was the nature of the liability being sought to be being imposed upon the partners. And he drew a distinction, the distinction I seek to draw in this case, the crucial distinction between the two different senses in which the words constructive trustee are used. One is a trustee who becomes a trustee because he intermeddles with the trust. He becomes a trustee de son tour, and thereby incurs the direct liabilities of a trustee. The other is the person who does not intermeddle in the affairs of the trust, but assists or procures in a breach of trust, and thereby incurs a secondary liability, but dependent, of course, upon proof of all the necessary mental elements for secondary liability. And he warns against confusing these two issues, saying at the same time they are often confused. And my lords, one can pick it up in his speech at page 402, paragraph 135. And my lords, top of page 402, 135, but every statement in a judgment must be understood in the context in which it's made. And this is particularly the case of employers' expressions such as constructive trust or constructive trustee, for they have more than one meaning and meanings have changed over time. Mara and Brown cannot be understood unless the sense in which Lord Herschel and Rigby LJ were using the expression constructive trust is appreciated. The case concerned a marriage settlement. The first defendant, whom I shall call HB, was a solicitor. He advised the persons who were acting as trustees, though not yet formally appointed as such. He suggested a series of investments for the trust funds. They were not proper investments for trustees to make. The money was to be lent on building property of a speculative character, and the margin was unsatisfactory. The investments were made, and the money was lost. Lord Herschel considered that if the claimants had charged HB, that is the solicitor, with negligence as a solicitor and brought the action in time, they might well have succeeded in such a case, in which case both HB and his partner would have been liable. But any such action was barred by the statute of limitations. Accordingly, the claimants alleged that HB had intermeddled with the trust and was liable as a trustee de son tour. They alleged that he had laid out the trust monies at a time when there were no trustees, and therefore must be taken to have acted as a principal in the matter, and not as a mere agent for the trustees. Such a claim was not statute barred. The judge agreed with this analysis and held that both HB and his partner were liable. The Court of Appeal took a different view of the facts. They held that it was not correct to say that at the relevant dates there were no trustees. But even if there had been none, HB would not have been liable. He did not intend or purport to act as a trustee, and no one supposed that he was so acting. He purported to act throughout only as a solicitor of the trustee and was understood by all concerned to be acting as such. This summary is sufficient to show what Lord Herschel and Rigby LJ meant by constructive trustee. They meant trustee de son tour, that is, a person who, though not appointed to be a trustee, nevertheless takes it upon himself to act as such and to discharge the duties of a trustee on behalf of others. In Taylor and Davis, Viscount Cave describes such persons as, though not originally trustees, they've taken upon themselves the custody and administration of property on behalf of others, and though sometimes referred to as constructive trustees, they were in fact actual trustees, though not so named. Substituting dog Latin for bastard French, we would do better today to describe such persons as de facto trustees. In their relations with the beneficiaries, they are treated in every respect as if they'd been duly appointed. They are true trustees and are fully subject to fiduciary obligations. Their liability is strict. It does not depend on dishonesty. So that's the first, my lords, that is, as it were, the de facto directorship liability. It's exactly the same line of reasoning. Like express trustees, they couldn't plead the Limitation Act and so on. And then there's a reference to how the Limitation Acts work. And then, para 139, in the same case, however, Viscount Cave identified a very different kind of constructive trustee. But the position of a constructive trustee in the usual sense of the words, that is to say, of a person though who he had taken possession in his own right was liable to be declared a trustee in a court of equity, was widely different. Taylor and Davis wasn't a case of fraud, but it was followed in Clarkson and Davis. In the latter case, Lord Justice Clark explained that the distinction was between a trust which arose before the occurrence of the transaction impeached and a claim which arose only by reason of that transaction. In the former case, the defendant is treated as a trustee, even though not expressly appointed as such. In the latter case, he is a stranger to the trust at the time of the transaction. I was pausing there for a moment. You can see why I emphasise that so much, because it is clear from the authorities that a director of a corporate director is a stranger to a trust in the case of the corporate trustee. It's exactly the phrase that's used. Referring to these cases in Paragon Finance, I drew attention to the fact that, which was becoming increasingly overlooked, that the expression constructive trust and constructive trustee were used by equity lawyers to describe two entirely different situations. One was the situation which the claimants unsuccessfully contended had arisen in Morrow Brown, and the other was the situation which arose in the present case. And then, unlike HB and Mara, Mr. Amherst did not assume the position of a trustee on behalf of others. He never had title to the trust funds or claimed the right to deal with them on behalf of those properly entitled to them. He acted throughout on his own or his confederate's behalf. The claim is simply that he participated in a fraud. Equity gives relief against fraud by making any person sufficiently implicated in the fraud accountable in equity. In such a case, he is traditionally, and I've suggested unfortunately, described as a constructive trustee and is said to be liable to account as a constructive trustee. But he is not in fact a trustee at all, even though he may be liable to account as if he were. He never claims to assume the position of trustee on behalf of others, and he may be liable without ever receiving or handling the trust property. If he receives it at all, he receives it adversely to the claimant. Okay. And then 142. In this second class of case, the expressions constructive trust and constructive trustee create a trap. As the court recently observed in Coulthard, this type of constructive trust is merely the creation by the court to meet the wrongdoing alleged. There is no real trust and usually no chance of a proprietary remedy. The expressions are nothing more than a formula for equitable relief. I think that we should now discard the words accountable as constructive trustee in this context and substitute the words accountable and equity. I submit this is a very powerful and important analysis for the purposes of this case, because what Mr. Green is really saying is de facto directorship is something you fix on people who've done wrong. You look at what they've done, and then if they've done wrong, you fix liability on them for their acts. My lords, I submit that is wrong. It conflates two different ideas. To get a notion of de facto trusteeship off the ground, you've got to show that before the relevant act was done, there was already a fiduciary and common law duty owed by the so-called de facto director to the underlying beneficiary. If there's no pre-existing duty, there's no question of his being liable as a primary party.
How does that actually work in a case such as this? You know, one's got a declaration of dividend going on frequently throughout the life of these companies. And the ones that are attacked occur comparatively late in the history of the companies.
Yes.
Is it enough to meet your objection that this was going on at an early stage, indeed from the very outset of the corporate structure? There you've got him actually assuming against you that this is enough. There it is. It's in place before the critical declarations take place.
No, if one can take it chronologically.
Right.
I would say, no, how does this work? What about the very first occasion, Mr. and Mrs. Holland?
Yes.
Let's say, are they de facto directors at that point?
Yeah.
Well, no. They turn up, let's say, for the board meeting. I'm just assuming, that there's more. They turn up for the board meeting, they say, yes, let's pay some dividends. We can do so. They are, at that moment, acting as the directors of paycheck directors. They are not, in any sense, stepping outside their role as directors of paycheck directors on that first occasion. What about next week? At that point, have they now got the fiduciary that have, at this point, next week to this, week 2, have they suddenly got a direct fiduciary and common law obligation imposed upon them, directly to the composite companies, which in week 1 they didn't have? And if so, why? Is it because they both voted at the first board meeting? It can't be right. As long as they are consistently acting within their powers as directors of paycheck directors. They're not stepping outside their powers as such. They never assume in relation to, as it were, the repeated meetings they have or repeated declarations of dividends. They never, as it were, somehow assume a direct fiduciary and common law duty which was not there in the beginning. It doesn't, so to speak, just emerge like the leaders of the Conservative parties gradually emerged. It's either there at the beginning or it's not. So that's what I say. In other words, this is the importance of Lord Millet's distinction between the two different ways in which reliability can come about. And it's terribly important not
Could
to
you
mix
just
them up.
help me on that beginning of paragraph 141 of
Yes.
Lord Millet? Sorry if you put it away already, but when he says unlike HB and Mara and Brown, does he mean like HB and Mara and Brown, or does he mean unlike HB in Mara and Brown if the result in the Court of Appeal had been different?
Well, I guess I agree, because HB, in a sense, was found not to have been.
He was, yes, he was.
Yes. I agree, my lords. Perhaps it could be.
Anyway, I've not misunderstood that.
No. I hadn't picked that point up, but looking back, I can see that it looks like an error. My lords, I don't propose to go through the various cases at first instance and some in the Court of Appeal about de facto directorship, because it's common ground what the general doctrine of de facto directorship is. The only question in this case is whether the capacity in which Mr. and Mrs. Holland acted makes any difference. Because I accept, for instance, if, let us say, without a lawful title, Mr. Holland has just barged into the boardroom and said, right, we're declaring some dividends today, then, and he'd done that repeatedly, week after week, well, of course he'd be a de facto director. He would be doing directorial acts without any lawful capacity for doing so.
Are you taking issue with the general principles that the trial judge set out in paragraph 169 at page 94?
I don't think so.
I don't think you are. They don't take us. They don't take Mr. Green the whole distance anyway. But I mean, so far as he goes,
Yes.
they seem to be.
I better just check.
Well,
what's the page?
Please do. But it's page 94 in the bundle, and he sets out 6 points which are vouched by authority as general principles.
My lords, no, I don't think I do take issue with that. My lord, having read this before, my lords, unless there's, if I can put it this way, certainly not with the generality, but I can't say I've, as it were, perused it for the tiny points of detail. But my lords, no, I would accept that this is a fair summary.
So it's always going to come down to what the individual does.
Yes.
In the way you've been explaining.
Yes, the individual has to do something. By virtue of doing something, he assumes, the law says, well, you've done that, you've assumed the office of director or manager, therefore you come under the duties of that, and you can't plead the absence of a valid appointment as a defence.
Yes.
But it simply doesn't help you in this case. Namely, what if he has got a valid title for doing what he's doing? And that's the question. And I submit, if he has got a valid title for doing what he's doing, then you can't treat him as a de facto director. You can, of course, get him under secondary accessory liability principles if he is dishonest himself. So it's not my defence that he can never be personally liable, but that he's not directly liable for breach of a direct fiduciary and common law duty. And on the findings of fact, in this case, my lords, it's crucial, because, of course, the judge found that Mr. Holland acted honestly at all times. There would be no basis for a finding of secondary liability against Mr. Holland on that basis. And that's why it's so important that one identifies what exactly is the scope of the de facto directorship rule and the distinction between that and secondary liability. My lords, I was going to go to the hydrogen case at tab 34 in bundle 4. My Lords, Mr. Green took you through this yesterday. My Lords, just to remind you, just the head note, the first paragraph. Eagle Trust plc had a wholly owned subsidiary, Midland City Partnerships, which in turn had a wholly owned subsidiary, Land Saver. Hydrodam, the company, was a wholly owned subsidiary of Land Saver, 19. The company had two corporate directors. The company went into liquidation. Liquidator began proceedings against two of the directors of Eagle Trust, that is going right back up the chain, alleging that they were liable under Section 214 of the Insolvency Act as de facto or shadow directors. They applied to have it struck out. My Lords, the passages which I particularly wanted to go through in this judgment are, first of all, on page 184. Second paragraph, the liquidator submitted. The liquidator submitted that where a body corporate is a director of a company, whether it be de jure, de facto or shadow director, its own directors must ipso facto be shadow directors of the company. In my judgment, that simply doesn't follow. Attendance of board meetings and voting with others may in certain circumstances expose a director to personal liability to the company of which he is a director or its creditors, but it does not without more constitute him a director of any company of which his company is a director. My Lords, can I pause there for a moment? That's very important. In other words, doing a directorial act, namely turning up to a board meeting in relation to the corporate director, doesn't make you a director of the underlying company. My Lords, I emphasise that because my learned friend somehow suggests that what if you turn up to the board meeting, which is after all a directorial act, but you're passive at that board meeting, you don't do anything. Would that mean you're not a de facto director? In my submission, this has nothing to do with passive and active, because the premise of all this is that the directors are doing directorial acts.
He's assuming that you've got the word with others.
With others, yes.
So, I mean, this is the standard situation of a board of a number of people, all in accordance with Table A and so on and so forth.
Yes. Mm-hmm. Well, my Lords, I submit it wouldn't make any difference if he was the sole director. It wouldn't, without more, constitute him a director of any company of which is... So in other words, it is still a directorial act. These people are doing... I mean, leave on one side. It is a directorial act that these people are doing. And my Lords, if, for instance, let us say someone had turned up at that board meeting who was not a director, and not a properly appointed director, then of course he might well be liable to the company whose board meeting he turns up at. But it doesn't follow he's going to be liable also as a de facto director to the underlying company. My Lords, it then continues. It's not alleged against Dr. Hardwick that he did anything at all in relation to the affairs of the company, that's the underlying company, nor not even that he voted as a director of Eagle Trust in respect of any matter in relation to the affairs of the company. And my Lords, important in my judgment, the mere fact that Dr. Hardwick was the director of Eagle Trust does not establish that he was either a shadow director or de facto director of the company. The expression collectively responsible obscures the relevant legal relationship. By reason of his appointment as a director of Eagle Trust, Dr. Hardwick owed fiduciary duties and a duty of care to Eagle Trust. And it doesn't follow that he ever gave instructions to the directors of the company, or that the directors of the company were accustomed to act on his instructions, nor does it follow that he ever acted as a director of the company. It is possible, although it's not so alleged, that the directors of Eagle Trust as a collective body gave directions to the directors of the company, and that the directors of the company were accustomed to act in accordance with such directions. But if they did give such directions as directors of Eagle Trust acting as the board of Eagle Trust, they did so as agents for Eagle Trust, or more accurately, as the appropriate organ of Eagle Trust. And the result is to constitute Eagle Trust, but not themselves shadow directors of the company. My Lords, that was the point I was seeking to make earlier this morning, in answer to Lord Collins's question. In practice, in a case of the present kind, it's much more likely that it will be found that the executive directors of the ultimate parent company, or some of them, have from time to time individually and personally given directions to the directors of the subsidiary, and thereby rendered themselves personally liable as shadow directors of the subsidiary. If all they've done is act in their capacity as directors of the ultimate holding company in passing resolutions at board meetings, then in my judgment the holding company is the shadow director of the subsidiary, and they are not. My lords, I submit that is absolute, and it is quite clear what that is saying. It's not drawing any distinction between active and passive directors or anything like that.
It's quite odd that Eagle Trust was one of the defendants who was not struck out, and Lord Justice Millett, on this appeal from a strikeout, is effectively appears to be prejudging the case against Eagle Trust, but we don't know what happened later.
No, well, perhaps he was giving a steer, my lords, I don't know.
Perhaps he was, yes.
But my lords, I submit the meaning of this is clear. There's no two ways about it. My learned friends suggest there's more what Mr. Justice Millett is distinguishing between is the passive and the active director. It's clearly not what he's distinguishing between. He's saying that if you turn up to a board meeting on the corporate director and you voted it in favour of a resolution, let's say, which affects the subject company, you're not to be treated as a de facto director of the subject company, even though you've done something active in relation to the underlying company. And I submit that the interpretation placed upon this paragraph by Lord Justice Rymer in the Court of Appeal is entirely correct. My lords, I've forgotten the reference to it, but I noted it in my case, but Lord Justice Rymer summarises the effect of it at paragraph 66 of his judgment. If I can just ask you to look at that. Behind tab 2, behind tab 2 in the court number. The essence of Miller J's reasoning is the membership of the board of the corporate director will not, without more, make such member a shadow or de facto director, of which the corporate director is a director. Nor, in my judgment, did Miller J convey or suggest, or intend to convey or suggest, that the requisite more would be satisfied merely by active participation of the board member in making board decisions by the corporate director in relation to the actions of the subject company. On the contrary, I read him as indicating the reverse. See, then he says, see in particular the paragraphs I've just referred to. My lords.
There's a bit more reasoning in paragraph 67, about
yes.
two-thirds of the way down, which you might find helpful.
My lords, yes.
And the little more, or the more rather,
yes.
Perhaps is focused in the last sentence of paragraph 67.
Exactly. Well, my lords, he makes the point rather more succinctly than what I've been trying to make earlier. He will only become such if he steps outside the confines of his role as a member of the board of the corporate director and acts directly in relation to the affairs of the subject company. My lords, I submit that is clearly right.
You wouldn't put it quite that way. You would say acts as if he were a director.
Yes, acts as if he were a director, yes. Or indeed, I would go as far as say, and having done so, then fails to act as he should do, once he's assumed that office. In a sense, my lords, one can analyse de facto directorship in this way. The first question is, have you done anything in the first place to show that you are, to indicate that you are assuming the office? Once you have done something to assume that office, then you come under both the duties, both active and passive, if I can put it that way, of that office. You must do things and not do things. So, for instance, as in Gibson, he's assumed the role of a manager. He is then responsible for getting in the returns. And if he fails to do so, he's in breach of his duty as manager. He can't just say, oh, well, hang on, the doctrine of de facto managership only applies in relation to my acts, and I can't therefore be done for my omissions. On the contrary, once you've assumed that office, however it is you've assumed it, without a valid appointment, you're liable to the full extent of a properly appointed officer, both for omissions and acts. My Lords, I just wanted to I've referred briefly to the case of Richborough. Perhaps I should take you to that. It's in bundle 5 at tab 42. My Lords, can I just take you to a passage at page 524. This was a Company Director Disqualification Act application. And it's the heading, what is a de facto director? My Lord, I submit that what is said here is consistent with my proposition and indeed with Mr. Justice Millett's judgment in Hyderabad. However, a different and far from straightforward question arises as to what amounts to acting as a director or assuming to act as a director. In a case such as Morrison Canson, or Lowline, it would be clear from the absence of any validly appointed director and the practical situation in the de facto director is the person who conducts the management of the company's affairs. In other cases, it's more difficult. The difficulty arises, particularly in the present case, from three factors. First, there were other validly appointed directors who were active in the management of the company. Second, Mr. Muncaster's acts could be referred to a different role in relation to the company, namely that of the provision of consultancy services on behalf of Jade under the consultancy agreement. Third, it is also necessary to consider the interest and status of the shareholders. Although Mr. Muncaster was not a shareholder, it seems to me that he was acting in practice on behalf of Jade, which was a shareholder. It was recognised by those concerned that the shareholders had a role and a say in relation to certain of the more critical acts and decisions facing the management. It seems to me that for someone to be made liable to disqualification under Section 6 as a de facto director, the court would have to have clear evidence that he had been either the sole person directing the affairs of the company or acting with others all equally lacking in a valid appointment, as in Canson, or, if there were others who were true directors, that he was acting on an equal footing with the others in directing the affairs of the company. My Lords, that passage was later doubted, but that doesn't matter for present purposes. It also seems to me that if it is unclear whether the acts of the person in question are referable to an assumed direction or to some other capacity, such as shareholder or, as here, consultant, the person in question must be entitled to the benefit of the doubt. And my Lords, leave on one side the question of burdens of proof and should it be benefit of the doubt. The important point there is Mr. Lloyd, you see as he then was, is plainly recognising that if your acts are referable to some other capacity, then, my Lord, he's not a de facto director of the relevant company. In other words, capacity in which the acts are done is crucial to the question of de facto directorship. The reason is it's crucial in deciding whether a direct fiduciary and common law duty has been assumed by the person in question. My Lords, my learned friend referred you, finally, this is on the decisions relating to de facto directorship, to the case of Hall, which one finds at volume 6 at tab 51. My Lords, there's just a couple of points to note. My learned friend took you to the facts in this case yesterday. I submit it's difficult to place much reliance in this case, and the reason I shall explain why in a moment. My Lords, the first thing is Mr. Nuttall was not represented, and so I think he was represented by a lay representative. He wasn't represented by counsel, and so the sort of arguments which one would have raised on his behalf don't appear to have been raised. Certainly not clearly. But what one does see in paragraph 16 on page 197, one of the arguments that was being run, and indeed it seems probably the main argument that was being run on his behalf, Mr. Nuttall challenges the jurisdiction of the court to make a disqualification against him because he was never duly appointed a director of Mercury or of any of the 6 companies. The question before the court is whether, in the context of proceedings under the CDDA, it is open to the court to pierce the corporate veil and treat Mr. Nuttall as a director of Mercury and the 6 companies because at all material times he controlled LDL, which was such a director. It's Mr. Nuttall's further contention that even if he can be treated as a director, he played no part in the management of the companies and cannot be held responsible for their defaults. So, my lords, I emphasise that passage because the context of the later comments appears to be against the background of an argument that the court can pierce the corporate veil in certain instances. Mr. Nuttall's prime point was you can't pierce the corporate veil. That appears to be the argument which his lay representative was seeking to put forward. You then go to Mr. Justice Evans Lone's conclusions in paragraph 30, page 202. And subparagraph 1 is uncontentious. He says there's no difference in the meaning of director in the Disqualification Act and in the Insolvency Act. And then subparagraph 2, in the Hydrodan case, my lords, I emphasise that Mr. Justice Evans Lone is intending to follow Hydrodan. Millet J finds that the director of a corporate director is not without more constitute a director, whether shadow or de facto, of a subject company. However, I do not read his judgment as saying that this can never happen. I can well accept that an individual, through his control of a corporate director, can constitute himself a de facto director of a subject company. It seems to me that whether he does or not will depend on what that individual procures the corporate director to do. In theory, I'm not bound by the judgment of Millet J. In Hydrodan, even putting on one side the authority of the judge, I would need convincing reasons for not following it. I can find none. Now, my lords, I accept there that he appears to be saying that, well, you look at what, as it were, even within his authority, you look at what he did.
Yes.
But at the same time, he's purporting to follow Hydrodan. And my lords, I submit he has misinterpreted Hydrodan. It's as simple as that. And that's why I emphasise the point that I'm not casting any aspersions on counsel who appeared for the Secretary of State, but when you've got this type of case, it is rather helpful to have arguments from legal representatives on both sides, because otherwise points won't be spotted which should have been. Subparagraph 3. It seems to me that in order to be constituted as de facto director of a subject company, a director of a corporate de jure director must cause the corporate director to take actions with relation to the subject company as would have constituted it a de facto director if the company were not already a director de jure. My lords, pausing there, it's not clear from that whether he's saying that is a sufficient condition or a necessary condition. If you just read that on its own, clearly that's a bare minimum. No one would dispute that. But is he saying that also satisfies the test? My lords, it's just not clear. You could read it either way. And then subparagraph 4, in addition, the degree of control which the director of the corporate director exercises over that company will be of relevance. In the present case, Mr. Nuttall's control was absolute, but the situation will be substantially different where the corporate director is controlled by a board with a number of members with different responsibilities. Equally, the shareholder control of the corporate director may be relevant. And my lords, again, that may be in the context of a piercing the veil argument. Maybe if the argument, I suppose, would be if you have complete and utter control, it may be easier to pierce the veil. My lords, I submit with the greatest respect that this judgment cannot be taken as an authoritative exposition of the law, and certainly, insofar as it conflicts with Hydrodan, I submit that the Hydrodan is plainly the correct judgment and not this judgment. So, my lords, if I can just summarise my conclusion on the second objection, what is the rationale of the de facto directorship doctrine? It is the de facto directorship doctrine is not a remedy imposed as a sort of constructive trust, or as a remedial constructive trust for wrongdoing by people who cause subject companies, or rather, to catch human beings who make directorial decisions. Rather, a person becomes a de facto director when, without a lawful appointment or title to do so, he does directorial acts in relation to the subject company and therefore brings himself under a fiduciary and common law duty, direct common law duty, to that subject company. And that will apply both in relation to omissions and commissions. Here, I say, by contrast, in the current case, Mr. Holland has a lawful appointment for everything he did, and all his acts in causing Paycheck Directors to carry out its function, and all his acts were done in causing Paycheck Directors to carry out its functions, and he was not, at no point did he usurp Paycheck Director's role or assume its role. On the contrary, what he did was to enable it to perform its role. And there's no case anywhere, in my respectful submission, which even begins to support the Revenue's case on this, apart from the case I took to a moment ago of Hall. And therefore, my lords, I submit Mr. Holland was not a was not a de facto director of the composite companies. He could not have been. My lords, I move to my third objection, which is really related to the second, namely that what really the Revenue is trying to do is, by a sidewind, is trying to pierce the corporate veil without alleging and proving sham or fraud. And I've already made the point that either you allege and prove that, in which case, of course, the court looks straight through the veil and fixes a direct fiduciary and common law duty on the relevant person to the subject company, or B, you recognise the separate legal existence of the corporate director and give effect to the chain of separate duties that arise down the chain. First from the director, the corporate director, to the corporate director, the corporate director, to the corporate director itself, then from the corporate director on down to the subject company. And my lords, if I can just remind you of, I think it's what Lord Halsbury said in the second paragraph on page 33 of Salmon, where he says, speaking of the Court of Appeal, they don't really seem to be sure in their minds whether or not to recognise the existence of this as a company. I submit you must recognise it as existence of the company, and that's why you recognise the separate chain of legal relationships. And if the court recognises the separate chain of legal relationships, it cannot effectively say at one and the same time, I'm going to bring about exactly the same result in this case as if it were a sham. My lords, I don't propose to take you to the law related to corporate veil, but we refer to it in paragraph 29 of our case. We summarise what we say it is, and we rely in particular on a summary, I think, of Mr. Justice Cook in the Kensington case, which one can find in file 3, tab 18. My lords, I'm conscious of the time, and I don't want to take up time on what is not really a contentious issue, but I submit there is a summary there of what amounts to those cases when the court will pierce the corporate veil. The essence of it, my lords, is that some impropriety and dishonesty is required before the court will do that. And it won't do it just because the person using it seeks to limit his liability in some way, even if the court disapproves of that. As long as you act in good faith, you're not going to find the veil pierced. My lords, my learned friend says, but none of this really matters. Look at Oak Prime, the Pakistan shipping case, and the judgments of Lord Hoffman and Lord Roger. He says, look, they show that capacity doesn't matter. There you are, if you're a fraudulent director and you mislead a third party, you're liable in deceit. And you can't get away with it by saying, I was just doing that on behalf of my company. And so Mr. Green says that's an example of how a director cannot avail himself of a capacity defence. My lords, I submit that is simply wrong. The crucial point in Oak Prime is that was a deceit case. And all that did, my lords, was re-establish the proposition that if a director commits a wrong under the general law, such as deceit, then he is personally liable to the victim of deceit against whom he committed his wrong.
He can't say it was just the company, not me.
You can't just say that.
Yes.
And by laws, it had never ever been suggested before. Normally the argument was exactly the other way round. Normally the argument was we all take it for granted that the director's liable in deceit. The only question is whether the company is vicariously liable, bearing in mind he's been deceitful. I mean, it might have been said to be a surprising decision by the Court of Appeal, but there's nothing surprising in the House of Lords judgment saying that, well, of course, the director is personally liable for his own deceit. And that's because everyone is under a general duty under the law not to commit deceits against each other. But that says nothing about the question you've got in this case, which is, well, when is a direct fiduciary or common law duty of care to be imposed upon someone? In the first place, such as to make him liable to third parties, whether that third party be some other contractor or indeed some underlying company. And my lords, the really important case is not Oak Crime, but the Williams case.
Sorry,
Williams and Natural Life case, which is another House of Lords decision, in which it was sought to be, in which a director was sued after his company had gone under in negligent misstatement, and the idea was that he had made negligent misstatements, and he said, well, the company may have owed you a duty of care in relation to these statements, but I personally didn't owe you a duty of care. And that was the issue in the case. In other words, there's a distinction between the company owing a duty of care, in this case to a third party, and the director of the company owing a duty of care to the third party. My lords, you can find that at file 7, tab 67. Now, can I just go first to the headline?
What has this got to do with this case?
When do you impose a duty? In other words, it's my answer to what I would call the Oak Crime point, and the importance of recognising the corporate veil when you're looking at the liability of directors for, in this case, negligent mistakes. But my lords, the crucial point here is that this was an attempt, albeit in a different context, to say that a director had contracted a duty of care to a third party, notwithstanding that he was acting as a director of a company. And my lords, there is discussion in this case about the more general problem about directors of companies and what duties do they owe third parties. My lords, from the headnote you'll see the second defendant began to work in the health food trade in about 1980 and 1986. He formed the first defendant company to franchise the concept of retail health food shops. He was the managing director and principal shareholder, and his wife, also employed by the company, was the other nominal shareholder. There were two other employees, P and S. In 1987, the plaintiffs approached the company with a view to obtaining a franchise. They dealt with P. He gave them a brochure which advertised the second defendant's experience in the health food trade. The company sent the plaintiffs detailed financial projections, in the preparation of which the second defendant had played a prominent part. The plaintiffs didn't know the second defendant and had no material pre-contract dealings with him. They entered the franchise agreement, but the turnover from their shop proved to be substantially less than predicted by the company. They traded at a loss for 18 months. They sued the company for damages representing the loss that had been suffered as a result of the company's negligent advice, their cause of action being based on an assumption of responsibility by the company. In 1992, the company was wound up, and the plaintiffs joined the second defendant as the defendant to the action, their claim against him being based on the assumption by him of a personal responsibility. The action proceeded, and Mr. Justice Langley gave judgment, but the headnote will see held, allowing the appeal, that to establish the personal liability of a director or employee, there had to be such an assumption of personal responsibility by him as to create a special relationship between him and the plaintiff, and determining whether there had in law been such an assumption and an objective test was to be applied, the primary focus being on things done and said by the defendant or on his behalf, and the question being whether the plaintiff could reasonably have relied and had relied on an assumption of personal responsibility, and so on. And my lords, the relevant passage I want to go to is at page 834D. And my lords, the first 884D, under the heading "The Theory of the Extended Hedley-Byrne Principle," there's a discussion of Hedley-Byrne and then Henderson and Merritt, and the notion of assumption of responsibility. But more importantly, at the foot of the page, H, it will be recalled that Waite LJ took the view that in the context of the directors of the company, the general principle was not set at naught with protection of limited liability. In Trevor Ivory, Cook P expressed a very similar view. It's clear what they meant. What matters is not that the liability of the shareholders of the company is limited, but that the company is a separate entity, distinct from its directors, servants, or agents. The trader who incorporates a company to which he transfers his business creates a legal person on whose behalf he may afterwards act as director. For present purposes, his position is the same as if he'd sold his business to another individual and agreed to act on his behalf. Thus, the issue in this case is not peculiar to companies. Whether the principal is a company or a natural person, someone acting on his behalf may incur personal liability and tort, as imposing vicarious or attributed liability upon his principal. But in order to establish personal liability on the principle of Hedley Byrne, which requires the existence of a special relationship between plaintiff and tortfeasor, it's not sufficient there should have been a special relationship with the principal. There must have been a responsibility such to create a special relationship with the director or employee himself. My lords, the reason I say that's important is because it meets the oak prime point. My learned friend says directors are liable for their torts. True, but the question, that's only if they owe a duty, apart from things like deceit. If you're talking about a breach of fiduciary duty or a breach of common law duty, you've got to establish first that the director owes that duty. And you can't say the director owes that duty just because the company owes that duty. That's what one gets out of this case. And my lords, there's a discussion. If I can just mention it for your note. Page 835F, this page I've stopped on, the touchstone of liability is not the state of mind of the defendant. There's a passage that, in Lord Staines' judgment, going over to 836E, which discusses various cases, the Fairline Anderson case and then a New Zealand case, and a speech or paper by Lord Cook, discussing the problem of fixing personal liability, in this case the third parties, upon directors of companies. When can you do it? But the important point I want to make at the moment is simply that there is a substantial difference between the Oak Prime case and this case, and the more relevant general case, leaving aside the specific company law cases. So the problem you've got is the Williams case.
Yes.
My lords, I submit, therefore, the real question for you in this looking at this case here, the real question is: did Mr. Holland personally owe a direct fiduciary and common law duty as a director to the subject companies when he resolved to pay the dividends? If so, he was a director for his omissions and commissions. If not, he's not. Because if there's no duty, there cannot be a breach of duty. And the only basis on which a claim could be brought against him would be as a secondary liability claim. The second type of constructive trust claim talked about by Lord Millett. And my lords, I've made the point, there's no such claim pleaded against us. And my lords, can I simply say this? Any such claim would have been hopeless. If the claim against Mr. Holland was for procuring a breach of trust by paycheck directors, it would have been caught by TAN. My lords, can I just take the one point in TAN? It's at file 5, page 48.
Tab 40?
48.
48, sorry.
My lords, I just want to remind you, I'll explain why in a moment, just briefly in the head note, an important point on the facts, and then one passage in particular. The plaintiff airline appointed as its agent in a particular area for the sale of passenger and cargo transportation, a company of which the defendant was the managing director and principal shareholder. I emphasise that. Under the agreement, the company was to hold in trust for the airline money received from such sale until it was accounted for by the company to the airline. With the defendant's knowledge and assistance, the company paid the money into its current bank account instead of into a separate account. And in breach of trust, the company used that money for its own business purposes. The company failed to pay to the airline sums due within the time specified by the agreement. The airline terminated the agreement, and the company, having become insolvent, commenced proceedings against the defendant to recover the money owed by the company. The judge held that the defendant was liable as constructive trustee to pay that amount to the airline. On the Court of Appeal, Bruno Darussalam reversed that decision, holding the defendant couldn't be liable because it had not been established the company was guilty of fraud or dishonesty in relation to the money. And then on the airline's appeal, allowing the appeal that where a third party dishonestly assisted a trustee to commit a breach of trust, or, emphasise this, procured him to do so, the third party will be liable to the beneficiary for the loss occasioned by the breach of trust, even though the third party had received no trust property, and irrespective of whether the trust had been dishonest. that in the context of such accessory liability, honesty was to be judged objectively in acting dishonestly or with a lack of probity, and so on. So, my lord, that's the ratio. And then at the foot, Sonder, although mere negligence by a third party acting for or dealing with trustees would not normally render him liable to the beneficiaries in respect of losses resulting from a breach of trust, there might be cases where, in the light of particular facts, an honest third party will owe a duty of care to the beneficiaries in respect of the conduct of the trustees. My lords, the passage, you can see the passage which contains that at page 391 under the heading negligence. My lords, can I just emphasise that at one point, it was suggested in argument yesterday to Mr. Green that one of the points here is that Mr. Holland was, so to speak, a prime mover. In my submission, that makes no difference. The doctrine that there must be dishonesty applies not only to the person who assists in a breach of trust, it applies likewise to the person who procures the breach of trust. So even if you assume that Mr. Holland is procuring all these breaches of trust, because he's the prime mover, TAN still applies. Page 391 under the heading negligence. It's against this background that the question of negligence is to be addressed. The question, it should be remembered, is directed at whether an honest third party who receives no trust property should be liable if he procures or assists in a breach of trust of which he would have become aware had he exercised reasonable diligence. Should he be liable to the beneficiaries for the loss they suffer from the breach? The majority of persons falling into this category will be the hosts of people who act for trustees in various ways, as advisors, consultants, bankers and agents of many kind. This category also includes officers and employees of companies in respect of the application of company funds. All these people will be accountable to the trustees for their conduct. For the most part, they will owe to the trustees a duty to exercise reasonable skill and care. When that is so, the rights flowing from that duty form part of the trust property. As such, they can be enforced by beneficiaries in a suitable case if the trustees are unable or unwilling to do so. That being so, it is difficult to identify a compelling reason why, in addition to the duty of skill and care vis-à-vis the trustees, which the third parties have accepted, or which the law has imposed upon them, third parties should also owe a duty of care directly to the beneficiaries. They've undertaken work for the trustees, they must carry out that work properly. If they fail to do so, they'll be liable to make good the loss suffered by the trustees in consequence. This will include, where appropriate, the loss suffered by the trustees by being exposed to claims for breach of trust. Outside this category of persons who owe duties of skill and care, there are others who may deal with trustees, and so on. And then, second paragraph in 392, there remains to be considered the position where third parties are acting for or dealing with dishonest trustees. In such cases, the trustees would have no claims against the third party. And, my lords, passage finishes at 392C. But, my lords, I do respectfully submit that whatever claim possibly could have been framed against Mr. Holland before these proceedings began for accessory liability wasn't pleaded, and further, in the light of the judge's finding of honesty, could not have succeeded. My lords, can I just revert to one possibility?
One possibility.
One possibility which hasn't yet been covered, namely it's this. I've talked about secondary liability, procuring breach of trust and procuring breach of fiduciary duty and so on. My lords, yesterday the argument was floated in argument. Well, could it be said that Mr. Holland himself, so to speak, owed a direct statutory duty to the composite companies not to procure the payment of an unlawful dividend? So to speak, imagine the Companies Act having in it a section saying, no person shall cause a company to pay an unlawful dividend. My lords, in my submission, no. That's because the Companies Act do not contain any express statutory duty upon directors to that effect. They are not under a direct statutory duty by virtue of the Companies Act. Secondly, my lords, of course, if Mr. Holland is not a director, it wouldn't be any use the Companies Act saying no director shall do this. It would have, the argument against it would have to be, well, you as a non-director have caused a director to do this. Again, that would be a sort of secondary liability argument. But, my lords, what I submit the correct analysis is in relation to directors and dividends is this. Directors are under a common law duty to exercise reasonable skill and care, and also they owe a fiduciary duty. Now, one of the duties they owe, either by virtue of the common law duty or fiduciary duty, doesn't matter, is not to use their powers for improper purposes. And in the usual way, if a director were to pay an unlawful dividend, it would be said of him, well, you've gone and used your power for an improper purpose. That's to say, an illegal. You've used it to make an illegal dividend. But the basis of the director's liability is not some notional strict liability under the Companies Act. The basis of his liability is breach of fiduciary duty or breach of common law duty.
Well, is this, these submissions are really directed to the scope of Section 212, are they?
No.
Are they going broader than that?
No, well, I don't know, because it was suggested yesterday that perhaps one way one could analyse this case is there's a direct duty upon Mr. Holland not to cause a breach of the Companies Act.
I see.
If you see what I mean. You sort of treat it like a sort of statutory duty.
I don't think we've actually looked at Section 263 of the 85 Act. It's set out in paragraph 190 of the first instance judgment. A company shall not make a distribution except out of profits available for the purpose. I mean, that's pretty plain, isn't it?
Oh, yes. My lords, there's no doubt that a company cannot do it. My lords, I fully accept that. The question is, what is the, as it were, what is the liability, what is the conceptual basis of a liability of a director who causes that to happen? And my lords, the answer is one I gave, namely, he's going to be liable to the company because he has used his powers for an improper purpose. And so, my lord, in this case, what would the argument would be, the argument would go, well, Paycheck Directors, I'm assuming for the moment everything against me, Paycheck Directors has used its powers for an improper purpose and has therefore acted either in breach of duty, fiduciary duty, or at least in breach of its duty of care, one or the other. That would be the argument. But, my lords, that would not get Mr. Holland for having procured Paycheck Directors to do that unless there was some dishonesty on the part of Mr. Holland. And that's why it's important that one distinguishes always between primary and secondary liability.
Yes, in Flitcroft, it's regarded as a breach of trust, doesn't it?
Yeah, as a breach, but my lords, as a breach of trust, yes. My lords, the phrase that's often used is, you are liable as if for a breach of trust, or you are treated as having committed a breach of trust. And the reason for that is, of course, is not that you have committed a breach of trust, but you've exercised your fiduciary powers in relation to the funds the company has in an improper way. And so the court says, well, I will impose upon you the remedy which I would have imposed upon a trustee, because the position is so analogous. My lords, when one reads the judgments, I'll come to one or two of these later, they talk about as if, or as if you're in breach of trust. For instance, my lord, in Flitcroft's case, I think Lord Jessel speaks of quasi-trustees. So you're not in breach of trust as such. It's a misnomer to say the director's in breach of trust. He's not in breach of trust. He's misusing his fiduciary and common law powers. That's what he's done wrong. That's the basis of his liability. By 99 times in 100, it simply doesn't matter quite what the analysis is. Because it's so obvious that one would say it's a breach of virtually every duty you've got. There's no conceivable justification normally for paying out an unlawful dividend. So when you look at the cases, they don't analyse, except one or two, very carefully what is the precise basis on which a director is liable. But my lords, I'll come to this later. There are cases which say that the essence of his liability is actually, it's either he's got to be acting disloyally, i.e. breach of fiduciary duty, or at least there has to be some absence of reasonable care. But if what he does is pay out or causes the payment out of an unlawful dividend when he's acted reasonably and honestly, he's not liable. Because his duty is owed to the company, and his duty is to act in accordance with those two duties. My lords, if I can just ask this as a question. The question then is, in what circumstances does the court impose not just a secondary liability, but also a direct fiduciary common law duty upon someone involved in the affairs of a company?
To whom?
To the company. In other words, when does a person, say in Mr. Holland's position, come under a direct fiduciary common law relationship to the composite companies? My lords, I submit two things are necessary. First is he must do directorial acts in relation to the subject company. It's no use if he does things which are nothing to do with being a director. He's got to do directorial acts. For instance, turning up to board meetings. That would be a directorial act. Or secondly, the other requirement is that those acts have to be done by him without a lawful title. Some other lawful title. Those are the two preconditions for the imposition of de facto directorship. My lords, one might ask, what are directorial acts? If I can give examples, I would submit the following. First, taking part in board meetings and voting at them. So if a non-director turned up to a board meeting and started weighing in and saying, I think we should do this, and trying to influence the other members, he'd be a de facto director at that point. Or he would be doing that which he has no lawful title to do what he does, but he's doing it. Another thing, which is a directorial act, would be doing things without a board resolution, which need a board resolution. So if, for instance, a director on his own, if someone who's not a director suddenly negotiated a huge contract on behalf of the company without any resolution authorising him to do so, and quite outside the terms of his employment contract, then, my lords, one might say he's doing a directorial act. He's taking it upon himself to do something which only a director could do with the board's authority. But he's doing it without the board's authority. But, my lords, if all you do, if you just do things which you're instructed to do by the board, so you get a resolution from the board saying, you must do this, please, you please go off and negotiate this contract in France. And you then go and do that. And you're given a wide discretion as to what to do. And you negotiate a contract, you negotiate the price and everything like that. You are not doing a directorial act. You are simply doing something which you've been authorised to do by the board. My lord, someone who just does that is not rendering himself liable to the de facto directorship doctrine. Now, my lords, on the facts of this case, it's not suggested that Mr. Holland has done anything without paycheck director's authority. And the only relevant directorial act it can be said that he has done in relation to the composite companies is, in fact, the passing of resolutions to pay dividends. And therefore, if he is to be liable as a de facto director, it is because of his repeated role in making decisions to pay out dividends. That's the act that you'd identify that as, so to speak, the act which gives rise to his potential liability. But then, and my lords, I've always accepted that that act is obviously a directorial act, and that's why we've always accepted that, so to speak, one condition of the de facto-ship test is satisfied in his case. He has done directorial acts, or acts which only a director could do in relation to the composite companies. But you then come to the second question. When he did those acts, was he under a direct fiduciary and common law duty to the composite companies, to which the answer is no. My lords, can I put the question like this? When the directors of the corporate, let's say, take a general case, when directors of a corporate director sit in a boardroom deciding whether or not to make a decision that affects an underlying company, do they at that moment, as they're sitting in the boardroom, owe a direct common law and fiduciary duty to the underlying company before they make their decision? And I submit no. Not at that point. And so if, for instance, they make a resolution to pass a dividend, which let's say is a lawful dividend, one wouldn't say that in doing that they were acting as de facto directors of the subject company. You'd simply say what they've done is they've acted as directors of the corporate director. The corporate director in turn has authorised the payment of a perfectly lawful dividend. There's no question of any de facto directorship arising between, as it were, the directors of the corporate director and the underlying company. What if, my lords, the decision to pay the dividend, which they come up with at that meeting, is unlawful? Does the law, so to speak, retrospectively impose upon them some sort of fiduciary duty and say, well, yeah, you weren't under a direct duty before you authorised the payment of this dividend, but given that it was an unlawful dividend, we are retrospectively going to impose upon you a direct fiduciary and common law duty. Can the court do that? Well, my lords, the answer is no, for the reasons set out in Lord Millet's judgment. speech in the Dubai aluminium case. You can't, what the point really comes is you cannot retrospectively impose this duty after the event just because the dividend was wrongful. It was either there before or not at all. Of course, there may be accessorial liabilities if there's any dishonesty involved and so on. But, my lords, we're not in that territory. And, my lords, one can test this proposition, and in my submission also the wrongness of Mr. Green's case, in this way. Suppose you have this board meeting. My position is this: either all the directors of the corporate director or none of the directors of the corporate director at this board meeting at that point owe a direct fiduciary and common law duty to the underlying companies. Either all or none. It can't be that some do and some don't. Now, if all do, it cannot make any difference whether they are actively voting in favour of the unlawful dividend, or actively arguing in favour, or if they simply do nothing and pay no attention to the board meeting. And supposing you had 3 directors at this meeting, they're all under the same fiduciary common law duty, one assumes, to the underlying company. 2 of them are very active, they've prepared, but they're not very intelligent. The third one is the chap in charge of the figures. He's terribly lazy, he snores all the way through the meeting. He takes no notice of what's going on. He's totally inactive, and he doesn't even vote at the end. My lords, in my submission, the man who has snored all the way through the meeting and done nothing is every bit as much liable for breach of the direct fiduciary duty and common law duty as the 2 who have incompetently but conscientiously made the wrong decision. They're all going to be in breach. So the passive-active dichotomy my learned friend draws is plainly wrong. And I submit that very dichotomy gives the lie to his case and shows what his case really comes to, namely, it's an attempt to impose secondary liability by virtue of the acts you've done. Because my learned friend realises he cannot impose secondary liability by virtue of omissions. Of course you can't. And that's why I give you the example of these 3 members, and I say you are liable for your omissions as a de facto director just as much as you are for your acts. And what Mr. Green's case comes to is really an attempt to confuse the 2 categories of constructive trusteeship, as Lord Miller would have put it. My lords, can I mention one other point? It was floated yesterday. There are 2 stages to the payment of a dividend. The first is the resolution. The next is the payment. Now, my lords, what is actually prohibited by the Companies Act, I don't have it in front of me, no, it's in the judge's judgment, is the payment.
It's the making.
It's the making of the payment.
Yes.
Query whether that means the resolution as opposed to the payment. My lord, supposing, for instance, the resolution is passed, but then it's not acted on for some reason. I would respectfully submit there hasn't actually been any unlawful act committed at that point. What is the unlawful act is the actual making of the payment. Now, in this case, my lords, the question of making the payment doesn't arise, and it would seem that it was in fact Mrs. Holland who made the payment. One might ask, what is the duty of the person who makes the payment? Now, prima facie, the board the board has authority. It's the board who, as it were, has the mandate over the bank account. And if the board has authorised someone else to sign the cheques, then that person is acting by virtue of a delegation from the board. And the duty that that person owes to the company whose cheques are being signed is essentially a ministerial duty to act in accordance with the instructions from the board and with reasonable skill and care. But it's certainly not a directorial duty. So the actual paying out by Mrs. Holland of the dividends was not a directorial act, nor would it have been a directorial act if Mr. Holland had done it. And further, it would not, the wrongful act, if it is anywhere, is in the resolution rather than the making of the payment. Unless, of course, when you make the payment, you know the resolution has been passed dishonestly or something like that. My lords,
sorry, what are you asking us to take from there?
Well, my lords, I simply tried to work out what the analysis, what exactly is the wrongful act. And the wrongful act, in my submission, is not the payment itself, although The payment itself is not done as a director. The wrongful act is the passing of the resolution which results in the payment.
Because you've given us a lot of imaginary scenarios. I'm just thinking about what actually happened after the bombshell of the consultation with the leading counsel on the 18th of August 2004. Was there any evidence that Mr. Holland and Mrs. Holland decided that then they should have a formal board meeting with advisors present to discuss what to do? Was there any cross-examination about that?
I don't think so, my lord, no. My lord, I don't think so.
I mean, that's much more important, really, than the imaginary cases you're putting to us.
Well, my lord, yes, I was simply trying to analyse how exactly.
I mean, all we know is that at some stage the computer was turned on again, and the payment by whatever electronic means it was made happened again.
Yes.
That's all we know.
Yes. Well, my lords, I shall check, but my lords, certainly, I don't think there's anything in the judgment about it.
No, I've just been looking. There's a long discussion about the very late evidence of what was said on the train back to Crewe, but nothing, so far as I can see, as to what happened between Mr. Holland and Mrs. Holland.
Yes. Well, my lords, one can assume that the system which had previously operated continued to operate. My lords, I think that...
Well, it did, but after the bombshell that had been received, if ever there was going to be a formal board meeting to discuss things in a formal way, that's when you would have expected it to happen.
Yes. Well, my lords, we will check the evidence, but my lords, I'm not sure if it was in evidence. My lords, of course, they were husband and wife, so to that extent, one can imagine that there were no natural discussions, but they wouldn't...
Well, they seem just simply to have carried on regardless, as far as one can tell.
The idea of the period of grace, as I understood the discussion at 269 and 270, was to give him time to take stock and presumably decide what should be done. But nothing actually came out of that period, as the narrative seems to go.
Yes. My lord, at this point, I'm not on the question of whether or not the dividends are rightly or wrongly paid. My lord, I'm not trying. That's not the point I'm on. I'm simply trying to establish or rather argue what it is exactly amounts to a directorial act and how the payments.
And you're concentrating on the resolution, and all we know is that they had this wonderful hardware and software, and you just pressed the button and the resolutions came out. Dozens and dozens of them.
Yes, well, both directors were plainly prepared to pay the dividends, my lords. Of that, there's no doubt. Yes. But, my lords, there are the judge's findings, my lords. I don't need to repeat.
I mean, it's really the best one's got, I think. Maybe somebody finds somewhere else. It's the last sentence of paragraph 269, which is just saying that he continued to cause the composite companies to pay the dividend without taking all appropriate advice, without properly informing us as to the merits of the alternative courses of action, and so on. I think that encapsulates what seems to have happened.
Yes.
Without more detail. Well, is there more to be discussed in this chapter, Mr. Knox?
Yes, my lord, I've come to an end by what I call the third objection, namely, inconsistent. Essentially, it's an attempt to get round the rules about sham.
Yes.
But, my lords, the next objection we have is that the revenues proposition is inconsistent with analogous cases about corporate directors.
Yes.
And accessorial liability. And, my lords, you'll see how we put it in our case. I just want to take you to two cases, if I may, on that. The first is three cases. The first is the case of Wilson, which is at tab 68. In, I believe it's file...
Volume 7, sounds probably volume 7, isn't it? It's 68.
File 7.
Yes.
And my lords, if I can just take it to the head note and then just the one passage. Company was formed for the purpose of receiving money from depositors and investing it upon security. The defendants were directors of the company. The plaintiff deposited with the company the sum of £1,000 upon terms that it should remain in their hands for 5 years. They should meanwhile pay interest at the rate of 6%, and that by way of security they should transfer to the mortgage made to them, and that if the mortgage should become ineffective before the expiration of the 5 years, they would replace it by another. The mortgage upon which the £1,000 belonging to the plaintiff was secured was paid off before the expiration of the 5 years, but the company did not replace it by another and dealt with the proceeds as part of the funds of the company. The company ultimately went into liquidation. The plaintiff then sued the defendants to recover from them the sum of £1,000 paid by him to the company on the ground that it was lost to him by reason of the defendant's gross negligence. At the trial, it's proposed to show that when the mortgage was paid off, the company was sold, and so on. My lords, I just emphasise that the point here is that the directors did something. This is a case of the directors of the trust company taking steps which they shouldn't have taken. And if you look at page 531...
531?
531.
Yes.
In the judgment of Lord Justice Bray. So the second paragraph. But suppose there were a trust as between the plaintiff and the company, and that the company were trustees of the plaintiff. The subject matter of the trust would be the £1,000, the trust would be to invest and reinvest it. Then the suggestion is that the company committed a breach of trust in not reinvesting it when Catherine Dill's mortgage was paid off, and that the two defendants aided the company to commit such breach of trust and are therefore liable. The suggestion assumes that the defendants were not trustees of the plaintiff by reason merely of their being directors. They are, for the purpose of this argument, unless made otherwise by their acts, strangers to the trust. The doctrine applicable to the suggestion is laid down by Lord Selborne, Barnes and Addy, and then, my lords, the Barnes and Addy doctrine is then set out. My lords, what I submit is significant in this case is that it wasn't even argued that there could be a direct claim for a direct breach of fiduciary duty. The claim here being put against the defendant directors is that they have procured a breach of trust. My lords, that I submit is the right way of putting the claim, and it was then rejected on the facts. My lords, the Bath case, which my learned friend took you to, if I can go to that, it's at file 1, tab 7. My lords, I don't propose to repeat the facts of the case, I'd rather go to the head note again. My lords, you'll recall that the problem was that the company had awarded contracts to its three directors, a solicitor, an auctioneer, and a valuer. That was essentially the problem. The company, as a trust company, awards contracts to three of its directors. And my lords, I just emphasise that point because that was clearly an act done by the company, and clearly, therefore, an act done by the directors. And what was being challenged was the lawfulness of that act. Namely, you can't award yourselves contracts because you're in a fiduciary position. And, my lords, if the page 625 to 626 is the passage my learned friend took you to in the judgment, I think, of Cousins Hardy, MR. I don't repeat that. It's at the foot of 625 going over to 626. And then page 627... 7 lines from the end, I based my decision
Yes, we saw that
upon the
yesterday.
broad principle.
Yeah.
And my lords, all that is in the context of directors who've done acts.
Yeah.
If this is not omissions, this is acts that they've done. And so something more is needed than the mere awarding themselves of profitable contracts to bring them into a direct fiduciary relation with the beneficiaries. And my lords, Lord Justice Buckley's judgment, page 642, My Lords, what I particularly, and this is a passage again I think my learned friend took you to in the second paragraph,
Yes,
the
he
second
did,
paragraph
yes.
of appeal. The particular point I emphasise is this: a fiduciary relation can only arise either contractually or by implication of law. Well, we're obviously not here talking about contractually, we're here talking about implication of law. And then, finally, in the judgment of Lord Justice Fletcher Moulton, my Lord, page 637, I submit this paragraph, the second paragraph on page 630, it supports entirely Mr. Holland's position. My Lords, my learned friend took you to this and said it doesn't cover the point. I submit it does, and if I may, if I can just reread this paragraph, or not the whole of it, but just the relevant part of it. Nor do I think it would be in accordance with the principles of equity to hold that these considerations make them, the directors, liable for all breaches of trust on the part of the company, even though such breaches of trust were planned and carried out by themselves. The contractual liability of carrying out the trust is undertaken by the company, and it may involve responsibilities of a serious kind, depending on the right construction of their powers and duties. Honest error in such matters might well render the company liable in the same way as it would be liable for negligence, but the directors would not be liable in respect of such matters. But in my opinion, they are liable for matters of personal conduct inconsistent with their full knowledge of the fiduciary character of their duties, which in the name of the company they have to carry out. My Lords, that was the point on which Lord Justice Fletcher Moulton disagreed. He says, well, you, the directors, know that the company can't make a charge for this. You know that. So how is it that you personally can? That was his argument, to which the arguments of the other judges was, well, no, they can, because there's nothing preventing the company from awarding these contracts to these particular directors. And Lord Justice Fletcher Moulton looked at it from the other angle, saying, how can the directors honestly take these contracts? That was the point of difference, but there was no point of difference in the general principle that in doing acts, or rather in procuring the company to do acts, the acts of the companies, and there is no liability merely for negligence on the part of the directors owed directly to the beneficiaries. My Lords, finally I'd like to go to the case of JAPT, which is in File 2, tab 17. My Lords, again, this was a case of negligent acts by the trustee and indeed the directors who caused the corporate trustee to take them. Because £3 million, the directors caused the company to spend £3 million without security in purchasing a property. And my Lords, the relevant paragraphs I'd like to go to page 131E. My Lord, Mr. Justice Lindsay, having discussed 131E, having discussed Wilson and Bath and Standard land, notes a point made by Mr. Sher halfway down the page, 131E. Mr. Sher rightly points out that these cases do not deal with a one trust, no asset 30p company, such as the former corporate trustee, and that it is only a particular fiduciary disability, rather than the boundaries of fiduciary duty that were there in issue. However, there's nothing to distinguish, nothing in the reasoning of the majority to suggest that the court is to be required to, or should distinguish by reference to any discernible principle between substantial and insubstantial companies, or between the cases of trust companies with only one or more than one client trust. Moreover, although the result of the cases related to particular fiduciary duties, the disability was seen as part of the broader position of fiduciaries, and the result was arrived at by way of the broad statement of principles I've noted. I am, of course, not able to prefer the judgment of Lord Justice Fletcher Moulton, unless I can find some distinction. Subject to that, I regard myself as bound by the ratio, and so on. But, my Lords, the point I rely on particularly there is that this principle applies even if one is talking about a company or corporate trustee with very limited capital. It makes no difference. My Lords, over the page at 133, at 133b, there's a sentence, the principal is entitled to the single-minded right of his fiduciary from Bristol and West. And then after that, my Lord, dropping down a couple of lines, I do not see the Abbey Malvern case as adding real weight to the French Protestant hospital case. It revealed no principle which is applicable to the case before me, and certainly none in my judgment that at first instance can be referred to the ratio in Bath and the Court of Appeal. And this is the point I particularly rely on. As Mr. Mann emphasised, there is the additional curiosity. If third parties have all along been directly liable to beneficiaries for breach of duty of care owed directly to the beneficiaries, and without such third parties either improperly receiving trust property or dishonestly assisting in dealings with it, that the law should have been driven to develop the strict requirements of Barnes and Addy accessory liability, to which I shall now need to refer to below. My Lords, Mr. Justice Lindsay then goes on to discuss certain Australian cases, my Lords, which we have referred to in my written case, our written case. And I don't propose, my Lords, to reread those unless that would be of assistance. But, my Lords, the essential conclusion that Mr. Justice Lindsay draws is that there's no reason for departing, and he can't anyway depart from the general principle that directors of a corporate trustee do not stand in a fiduciary relation to the beneficiaries. And my Lords, that being so, the only way that one can say that they can impose liability is by virtue of the secondary liability routes.
Yes, well, that's the end of item 1 in the issues, is it? How are we getting on? Because there are 6 other issues.
I don't anticipate being too well. There's the loss issue, which is an important issue.
Yes.
Subject to that, I don't anticipate being long on the others.
Right.
My Lords, can I just mention one point, and that's on section 733 of the Companies Act.
Yes.
Is that my learned friend says, how can this section work if our arguments are correct? My Lords, I think that's a file 8.
Yeah. 733, did you say it was?
733. I think it's behind tab 76. Yes, behind tab 76, 733.
Yes, it is. Yes.
My own friend drew attention to this, saying, well, how does this work, if Mr. Holland's case is right? The following applies to offences under certain sections. My Lord, those sections deal with the passing on, or it deals with revealing information given to a company by the Inland Revenue. Where a body corporate is guilty of such an offence, and it's proved that the offence occurred with the consent or connivance of, or was attributable to any neglect on the part of any director, manager, secretary, or the similar officer of the body, or any person who is purporting to act in any such capacity, he, as well as the body corporate, is guilty of that offence, and he is liable to be proceeded against and punished accordingly. My learned friend says, oh, but how would Mr. Holland ever be made liable under this? My Lords, the answer to that is this. If you imagine, as it were, paycheck, the composite company being guilty of this offence, then of course paycheck directors would be guilty of it. Paycheck directors is itself a body corporate, and so in turn, under subsection 2, Mr. Holland would eventually be liable again. You would, so to speak, reread the section. So once you've got the composite company, you then get paycheck directors. That's uncontentious. Well, but then, if paycheck directors is guilty of an offence, then you start the sentence all over again, so to speak. That's the answer to that point.
Well, as I noted in the point, I'm not sure this is right. He said that if you're right, he escapes.
No, he doesn't. That's my point. He doesn't escape.
Yeah.
Because paycheck directors is itself a body corporate, and it is therefore itself guilty of an offence by virtue of subsection 2, and therefore you translate up to Mr. Holland.
Yes. Now, where do we go from here?
My Lords, we go to the second issue.
Issue
My Lords,
two.
we go to the remaining issues.
Right.
My Lords, I don't want to repeat the facts, but we summarise what I submit are the fundamental facts one has to bear in mind on the other issues in paragraph 75 of our case. I don't propose to read it out, my Lords, if I could just ask you briefly to remind yourself of what is said there.
Are you right in paragraph 7, page 34?
Yeah.
There's the words throughout the period.
Well, my Lords, yes. My Lords, there's no doubt that Neil Marston's speeches were involved in the setting up of the meeting with the revenue, and indeed were assisting to set up the new structure throughout that period.
It's just I'm comparing that with what the trial judge says in paragraph 269 in the last sentence, dealing with the period after the 18th of August 2004. The phrase "without taking all appropriate advice" and so on.
Well, my Lord, yes. I mean, the appropriate advice would have been specialist insolvency advice.
I see. So he was acting under the advice of Neil Marston and Speechless, who had been acting throughout,
Yes.
of course.
Yes.
I see.
Yes.
Yeah.
And my Lord, it wasn't as if he sort of just, as it were, said, "Oh well, I'm not taking any notice of anyone." The criticism was he just didn't get the specialist insolvency advice, which the judge said the situation required. And my Lords, it's very important this. This is why the judge finds that Mr. Holland was honest.
Yes.
He was in a terribly difficult position.
Well, he says, I think reading through 269, he didn't accept he was reasonable.
No, oh, absolutely not. That's why we lost.
Yes.
Had it not been for that, my Lords, it would have been the end of the case. But, my Lords, this is certainly not what the reason I emphasise this is it's not the sort of usual case like this of the directors who just, frankly, pay out dividends without even the shadow of justification. And this was a genuinely difficult position, resulting from the structure in which the structure of the companies. And there was a real dilemma. And my Lords, I submit that this is an important point. There were, in real life, only two options, and no one has suggested there was anything more than two options. One is stop instantly, don't pay out another penny in way of dividends. The other is, now, and the problem with that is there are going to be claims, and the judge accepts this, there are going to be claims both from the men for their minimum wage and in damages, and from third parties. They're going to be substantial. One doesn't know how much, but there's some evidence, but they're going to be substantial. That's one option. You stop straight away and bring down a whole lot of new creditors onto the composite companies. That's certainly going to damage them. My Lords, the consequence of that will be to eat into the existing reserves saved up for lower rate corporation tax, because there was no problem apart from the high rate corporation tax point at all. So the problem with this, you'd create new creditors which in turn would damage the interests of the revenue in collecting the lower rate corporation tax already saved up. That was one option. The other option is to keep going in the same way as before, obviously bringing in monies for saving up the money for lower rate corporation tax, but otherwise paying out the sums that come in. And my Lords, the judge accepted, I think I'm right in saying this, the judge accepted that you couldn't, as it were, alter the system and say to the men, oh, I've got to hold a little bit more money back from you this week, you're not going to get it all, they'd be off like a shot. And it was common ground between the parties that the men wouldn't wear any, as it were, alteration in their pay or reduction in their pay. So in practical terms, you had to either keep the system going as was or stop. And the question in those circumstances, one can look at it now and say, well, which was going to cause the companies and therefore the creditors the greater loss? The criticism, and the judge recognises that was the choice that had to be made, and that's why you should go off to an insolvency specialist and do the maths and work out what the thing to do would be and consult with the revenue. That wasn't done. And that's the criticism. My lords, there is this other curiosity in the case, and I submit it is a real curiosity. In the Norman event, one would say to the revenue would properly say, well, look, because you carried on, I didn't pick up the higher rate corporation tax, which I could have picked up from this men's labour had they gone off to another corporate structure. I mean, one imagines that, suppose all composite structures were liable to pay higher rate corporation tax. The revenue, in my submission, would justly say, look, you've really caused us an extra 144,000 quid's worth of loss because you carried on without saving up for it, and we're never going to get it off these companies. But the odd thing in this case is, of course, the judge found this too. He said it seemed to be the case, that no other corporate structure suffered from the defect this corporate structure suffered from. In other words, there were hundreds of other composite companies, structures around the country. None of them had this problem. They all operated on lower rate corporation tax without a liability to higher rate corporation tax. So if Mr. Holland had stopped, if he had stopped straight away on the 19th of August, the unusual feature of this case is that the revenue would not have been picking up higher rate corporation tax from any equivalent entity to which these men then had their labour contracted. So it's not an open and shut case where one says, well, you know, this was a completely mad thing to do. In my submission, it was not a completely mad thing to do. And indeed, if one asks, would anyone have gained if Mr. Holland had stopped instantly? The answer is no.
The way you're putting this suggests that actually Mr. Holland did properly inform himself about the consequences, because I don't think that's what the judge was saying.
And he didn't he didn't carry out a proper balancing exercise afterwards. There was evidence from him, unchallenged evidence, and this was always one of our complaints, in paragraph 12 of his second witness statement, to the effect that even before then, that he saw what the problem was, you had to carry on, hope you get a deal with the revenue, or stop. The difficulty with stopping was all the claims that would come in, and all that evidence was unchallenged. My lords, the criticism is after the advice from John Talon QC, he doesn't go off and get specialist advice. My lords, if I can draw your attention to the paragraph, part of his witness statement, which was not challenged. This was always this was a point which we've made before. It's in the second appendix, behind tab 6. He puts this at a slightly earlier point in time, but it's paragraph 12. Paragraphs 12 and 13, where he explains the thinking from the point in about mid-2004 when the judicial review application was being considered. And my lords, none of this was challenged.
Yes.
So, my lords, and this was always part of our defence too, it wasn't some sort of afterthought. So, my lords, I submit this is not, and this explains why the judge made his findings. So, my lords, that's the factual background to the other issues. And my lords, can I deal with the second and third issues together? The second issue is, what is the nature of the duty that's breached? What duty did Mr. Holland breach? And the third question is a related question, what is the remedy? And my lords, I submit that you can't answer the question, what is the remedy, without knowing what is the breach. And my lords, turning to the question of the duty, what is the duty that was broken by Mr. Holland, assuming he broke a duty? My lords, section 263 of the Companies Act places a duty on the company not to pay out dividends, save in certain circumstances. Therefore, if the company pays out, contrary to those sections, the company is in breach. My lord, a further consequence is that shareholders who receive monies, knowing of that breach, are themselves liable to restore the dividends, and that's section 277 of the Companies Act. There's no express statutory duty imposed upon the board of directors, or indeed anyone else, to say what is to happen if they have procured a breach. And so one asks, what is the legal basis of a director's liability if the board has passed a resolution? Now, my lord, is all the board jointly and severally liable, even those who voted against? Well, my submission, that can't be right. It would presumably be such directors on the board who have procured that decision to be made. And if in fact there's a vigorous dissent, it's difficult to see how the person who dissented from making the payment could be liable. And my lords, are the directors who are responsible for procuring that payment of the dividend automatically liable? I submit no. What if, for instance, one director has reasonably relied upon another director's opinion that there is sufficient funds to justify the payment of profits? I would submit in those circumstances he'd be entitled to say I've acted entirely reasonably. So he's not under a strict liability. But, my lords, I do say this, that board members who have authorised the payment of the dividends, who ought reasonably to have known that the payment was not justified, are in principle liable and guilty of a breach of duty. The question is, what duty is it? And I submit there are two possibilities. First,
Whereabouts is this in your case? Is this point?
Oh, it should be there.
I'm not saying this.
It starts, it begins at 76, and I described the judge's judgment at 78, where he explains why the dividends up until the 19th of August were lawful. And then, paragraph 83, I deal with the question of, or we deal with the question of when is there a breach? And what is the nature of the duty?
In answer to all this, paragraph 67 of the appellant's case says that this is a rather academic and fairly pointless point, because you can escape if you're found to have acted reasonably and so on, and because unreasonableness was the essence of the finding of the judge, a degree of fault has in fact been established.
Yes. My lords, I accept that point as far as it goes. But, yes, my lords, if one is talking about what's the remedy... Right,
I see.
That's the reason I want to put issues 2 and 3 together is because not so much... I'm not arguing at this point that Mr. Holland was not in breach of duty. What I am saying is, well, which duty? Yeah. What exactly is the breach one's talking about? Because that informs the question of the remedy. My lords, for a reason I'll explain in a moment, I submit it is clearly wrong. I submit really on whatever view of the law one takes, but it is important to identify what the correct breach is. It's clearly wrong to say that you restore the dividends unlawfully paid without an inquiry into the loss caused thereby. I submit, my lords, that is plainly wrong. But one does need to start first with the duty.
Does your submission attach any importance to the wording of section 212? Are we in 212 territory, or on your approach are we outside it?
My lords, it doesn't matter because section 212 is purely a procedural provision. It does not affect substantive rights. In other words, section 212 does not alter the substantive law as to what the director's liabilities are, either as to their duty or as to the remedies that can be imposed on them. My Lord, what essentially Section 212 did, and it goes back to the 19th century, 1865 Act, is it imposes a mechanism for the court to inquire into the director's conduct and then provide a summary remedy against him.
You mean that it can be done on the application of the official receiver and so on?
Well, I think that, and also to inquire into it. When you look at the old statute, my Lord, we do have it. There's a suggestion there, of course, in those days that the point could have been taken, well, I don't have to answer any of these questions. And the idea appears to be to enable effectively to force the director to answer questions, or at least to get him before the court so he would answer questions.
I think you'll find that from 1862 until 1985, it applied to misfeasance, whatever that means,
Yes.
or a breach of fiduciary duty. And in 1985, the Insolvency Act, later consolidated into the Insolvency Act 1986, introduced the words or other, or
Yes.
breach of fiduciary or other duty.
Yes.
So it is now significantly wider.
Yes.
Although almost all the cases are breach of fiduciary duty. But there's the odd case about the company director who spent the entire company fortune on buying jewellery, which he then took uninsured in a hold all to France and lost on the way. And he was held liable under Section 212 for negligence rather than breach of fiduciary duty.
Yes. Well, but my Lords, I of course entirely accept that.
One just has to bear that in mind in looking at cases earlier than 1985, that it was somewhat narrower.
Yes, indeed. My Lord, just to go back to your Lordship's point, Section 212 does not create new substantive remedies. In other words, you apply the law as always, you look at the common law, and all Section 212 is doing is providing a procedure. And the important thing it did originally was enable an inquiry to be made of the directors, but secondly, it gives a direct right of action to the creditor, which of course the creditor wouldn't have at common law. So apart from that, Section 212 doesn't alter the substantive duties of a director or the remedies against a director. My Lords, the judge in his judgment doesn't actually identify precisely what duty it was that was broken. He doesn't say this was a breach of the common law duty of care, for instance. He doesn't say this was a breach of fiduciary duty. Or he doesn't say, he just says this shouldn't have happened. He treats it as if it was a sort of strict duty.
So this is your paragraph 91. You're saying that because of that, the judge and the Court of Appeal should have held that it had not been proved that either of these, one was not argued and the other was not proved.
Well, my Lords, I do take that point. My Lords, if I can revert to that point. It's a short point. I don't want to spend too much time on it. Because, my Lords, I accept that the force of the point that you should have taken advice.
Yes.
It's fair to say that wasn't actually put to my client and it wasn't pleaded against him, but, my Lords, nonetheless, the fact is I've got two findings against me. It has been held he should reasonably have taken that specialist advice. Yes. That's the criticism of it. Now, my Lords, one then asks, well, what exactly is the breach of duty here? Because it's terribly important when one gets to the question of remedy. And my Lords, I've tried to identify one has to go back, as it were, to basics. What are the duties under which a director operates? And there is the breach of, basically, one could say, theoretically, two things. First of all, Mr. Holland acted in breach of fiduciary duty if he made the payments out disloyally. In other words, that is the essence, subject to immaterial qualifications, of a breach of fiduciary duty. You have acted disloyalty, without loyalty. Or you are a breach of your common law and equitable duty of care for acting without reasonable skill and care. And my Lords, that, acting without reasonable skill and care, is not a breach of fiduciary duty, and I'll come to that in a moment. I submit those are the two breaches that one would be identifying. Breach of fiduciary duty, alternatively, breach of common law, equitable duty of care. But I submit there's no, so to speak, strict statutory liability as such. My Lord, what
So it's
is
a breach of what? The equitable duty of care imposed upon the fiduciary, is it?
Yes, yes. My Lords, if I can go to Lord Justice Millett's judgment in Bristol and Western Moseley, where he, at some length, I hope I can just take one or two passages, explains at some length the difference between a breach of fiduciary duty on the one hand and a breach of the equitable duty of care owed by a fiduciary on the other, and of the importance of distinguishing between the two, and of the totally different remedies that apply. And that, my Lord, that's why I think it's important on the question of remedies, to identify what exactly is the breach in this case. My Lord, that's at file 1. Tab 9. Now, this involved solicitors who'd acted both for purchasers and a bank, and questions arose as to its conflicts of interest between the purchaser and the bank. But, my Lord, I don't need to take you to the facts, because there's a general exegesis of the law in relation to fiduciaries, which starts on page 16 at C. And, my Lords, if I could just take one or two extracts from this judgment, my Lords, but can I just say the whole of the passage from 16b to 18f is really, in my submission, crucial, and as far as I'm aware, is recognised widely as an authoritative exposition of the duties on the fiduciary. And my Lords, if I can just take the first paragraph, breach of fiduciary duty. Despite the warning given by Fletcher Moulton LJ and Ree Coomber, this branch of the law has been bedevilled by unthinking resort to verbal formally. It's therefore necessary to begin by defining one's terms. The expression fiduciary duty is properly confined to those duties which are peculiar to fiduciaries, and the breach of which attracts legal consequences differing from those consequent upon the breach of other duties. Unless the expression is so limited, it's lacking in practical utility. And then there's a quotation from judgment of Mr. Justice Southerns. The important point of that extract is the last sentence of the extract. But to say that simple carelessness in giving advice is such a breach is a perversion of the words. In other words, the solicitor who gives you negligent advice is not as such in breach of fiduciary duty. And then, dropping down to F, it is similarly inappropriate to apply the expression to the obligation of a trustee or other fiduciary to use proper skill and care in the discharge of his duties. If it is confined to cases where the fiduciary nature of the duty has special legal consequences, then the fact that the source of the duty is to be found in equity rather than the common law doesn't make it a fiduciary duty. Common law and equity each develop separately. And then there's an extract from Lord Brown-Wilkinson's speech in Henderson and Merritt, where he explains the liability of a fiduciary in relation to negligence, but that is in relation to his breach of equitable duty of care. In the passage going over the page to page 17. And then, if I can take it from 17b, I respectfully agree and endorse the comment of Ipswich and Permanent Building Society. It's essential to bear in mind that the existence of a fiduciary relationship does not mean that every duty owed by a fiduciary to the beneficiary is a fiduciary duty. In particular, a trustee's duty to exercise reasonable care, though equitable, is not specifically fiduciary duty. And then the director's duty to exercise care and skill has nothing to do with any position of disadvantage or vulnerability, not a duty that stems from requirements of trust and confidence imposed on fiduciary. In my opinion, that duty is not a fiduciary duty, although it's a duty actual in the equitable jurisdiction of the court.
It's quite well put in Gower, just by saying that in any event, breach of a duty of care arising historically in equity gives access only to compensatory remedies.
Yes.
And summarising that case.
My Lords, at 17g, the passage I particularly rely on, the remedy which equity makes available for breach of equitable duty of skill and care is equitable compensation rather than damages. That's the product of history. Compensation for breach of the duty of skill and care resembles common law damages and is awarded by way of compensation to the plaintiff for his loss. There is no reason in principle why the common law rules of causation, remoteness of damage and measure of damages should not be applied. by managing such a case. It should not be confused with equitable compensation for breach of fiduciary duty, which may be awarded in lieu of rescission. And then there's a discussion over the page.
What's the issue between the parties on this point?
Well, my lords, it's a huge issue. My learned friend says this: Mr. Holland must restore all 1.3 million dividends paid out from 19th of August to October 2004, without regard to the fact that the loss was nowhere near that.
Well, he says you can't look at the particular creditor, I think he says.
No,
and look at his particular loss.
In that period, the deficit of the composite, the simple way of looking at it is this: in that period, the deficit of the composite companies increased by at most the unsafe for higher rate corporation tax. In other words, the deficit increased by at most £144,000. The reason is because each payment out of dividends kept the workmen going, so they keep working. More money, then the companies get paid for their work. They get paid, as it were, the going rate for their work. The consequence of that, and then the money is paid out to them to keep them going from week to week. And so what you've got is a situation where the payment out of the dividends doesn't result in a net loss at that particular moment. It brings in a benefit. And so if you look at the net position over the 10 weeks or so, 8 weeks or so, the loss to the companies is not £1.3 million. The loss at most was £144,000 odd. My lords, that has always been our argument.
Well, there was interest on about 2.5 million ticking up, wasn't there, as well?
That was kept in the company's accounts, yes. For the money which should have been paid before August 2004 was about 2.5 million. Yes.
And there would be interest on unpaid corporation tax on that.
Yes, my lord, I accept that. My lord, I think it's also fair to say there was interest popping up in the company's accounts anyway, which had all the lower rate corporation tax kept. Right. But my lords, in any event, my lords, I accept there was that. But the fact is that the consequence of continuing to trade was not to cause these companies £1.3 million worth of loss. It's never been suggested that was the case at all.
Can I just show that I've got my bearings correctly? I'm looking at paragraph 271 of the trial judge to just see where it fitted into his discussion. Are you supporting his approach, are you? I mean, he's saying there that prima facie, the liability is to repay the dividends, but in fact, he limits the award to the amount of the HRCT that the composite companies failed to provide for.
Well,
now,
yes, my lords, what he's doing that not as a matter of the law, he's doing that by way of discretion under section 200.
Well, that's what I thought.
My complaint is
that
it's the law. My lords, I should say this: the actual quantification question was not before the court, because this was a trial on liability. But we did argue what is the proper approach to quantum, bearing in mind. My learned friend said you just restore the unlawfully paid dividends without regard to the loss caused thereby. My position was on the contrary. You look at the net consequence of the unlawful payment of dividends. If the net consequence of the unlawful payment of dividends of £1.3 million as to the companies has been to cause them a loss of nil, taking into account A, the benefits received back from those dividends, plus B, the savings made because there was an orderly transfer, rather than all the new third-party creditor claims coming in, which would have come in on the cessation of trade. My argument was, well, then there would be no liability at all. That would be a matter to be assessed on an assessment. That was the difference between us. And so, my lords,
where you're going to end up, I think, is your paragraph 105. Then, in your case, is it that you're seeking an order or either simply a reversal on the order of liability? Sorry, it's really picking halfway down 105 on page 47. Yes. That it's not entitled to restoration of the judge's order if the revenue succeeds, but only to an order that it's entitled to an assessment on the footing set out on that page.
Yes.
So that's where your argument goes.
It's not an issue. One can easily see that the loss was nothing like £1.3 million because the increase in the deficit was only £144,000. And my Lord Justice Elias, and if I can just take you to his judgment, he explains the point in his judgment in, I think, tab 2
Tab 2 in
of
one.
the core bundle.
Sorry,
Paragraph.
Oh, yes, yes.
My Lords, this was accepted by Lord Justice Elias, and my Lords, I think it can't be gainsaid.
Paragraph number?
Paragraph 119. 119.
Thank you.
Yes.
Unusual feature of the case. Usually when dividends are paid to shareholders, nothing is secured in return. Accordingly, unlawful payment of dividends for undistributed profits will generally deplete the company's assets by the amount distributed. In this case, however, the dividends are in substance remuneration for services rendered by the shareholder employees, so the actual loss resulting from unlawful payment of dividends is reduced to the extent to which profits are generated by the company's activities. Now, my Lords, that was one point that I took. And I said, as a matter of law, you have to credit the benefits resulting from the unlawful payments of the dividends against the liability to compensate. My Lords, the other benefit I submit one has to take into account is the savings made as a result of taking this action. If we are right in saying, and my Lords, our case was that we hadn't come up with the figures, but it would be hundreds of thousands of pounds were saved by taking this course of action. The consequence would be that although the companies ran up an extra liability of £144,000 higher rate corporation tax in the relevant period, on the other hand, they were saved a liability far greater than that. And my Lords, if that is right, my Lords, that issue is not before you, but I say as a matter of principle, if that's right, the savings made outweighed the losses sustained, then, my Lords, there was no loss sustained as a result of the wrongful act.
Well, are you saying that we can simply assert that on what we know?
No. My Lords, that's the argument which we would want around on an assessment of damages.
Right.
The question is, as a matter of law, is that an argument that would be open to
Yes,
us?
I see.
Because what's said against me is no. What you do is you just look at the amount of the unlawfully paid dividends without regard to anything else at all. And my Lords, the judge put it in his judgment without an inquiry into the loss sustained by it thereby. The judge was accepting that this was couldn't have been anywhere near the loss. He says that's irrelevant. My Lords, and my case is that there's no doctrine anywhere in the law that says a trustee or fiduciary who acts in breach of his duty of care, or indeed fiduciary duty, is under a duty to pay compensation greater than the loss caused by the victim.
And does Lord Justice Elias accept that? Where does he accept it?
My Lords, no, he doesn't accept that as a matter of law. He agrees with Lord Justice Ryman's judgment on that legal point, saying no.
So he says you're wrong.
He says I'm wrong on that point, but then he says under section 212 I can limit it, which is what the judge did too.
Yes, I mean, paragraph 125, he says that the basic obligation is to restore the monies wrongly paid out.
Yes.
That's his starting point. And then he says, well, you've got to can look at 212, and he looks at the period of grace and so on and so forth.
Yes.
But so he's against you on this point. And,
Against me on this
and-
particular point.
And
Yes.
Lord Justice Ward, he
I don't think he
doesn't really comment on this,
No,
does
he doesn't really express a view on that, I don't think, my Lords.
The crucial case on this is Bairstow, though, isn't it?
Well, and target, yes. Indeed, my Lords, yes. Because I accept, I'll come on that if I may. But my Lords, just as far as the facts are concerned, those are the facts I want to be able to, if this were ever got this far, the facts I would want to advance in the assessment of damages are bring into account the credits received, or the benefits received from the payment of the dividends as a credit against the liability, and also bring into account the savings made. And I would then go on to say, if that's the right approach, then when one works out the maths, there's nil loss. My learned friend says, no, you don't even get into that. You just pay back the unlawfully paid dividends without regard to the loss, which I say that's astonishing. I say there's no authority anywhere that says that. And I'll come to that if I may. But my lords, just going back to the question of what is the breach of duty involved, the breach of duty in this case, in my submission, was a breach of the duty of equitable skill and care, or the common law duty of skill and care. And the proper assessment of damages is the same, namely to compensate the victim for the loss. Because Lord Justice Millett said in Bristol and Western Motive, there's no difference between the way you assess equitable compensation in that instance and common law damages. My lords, the question then arises, if I'm right in saying that basically this was a case of a breach of the duty of skill and care, how does one assess the damages? I say you do it in the normal way. There are different rules for remoteness in equitable compensation and common law damages, but causation questions are the same. And I make this basic proposition of law. There's no case anywhere that says equitable compensation for breach of trust, or indeed for breach of fiduciary duty, is ever awarded in a sum greater than the actual loss. There's no authority that says that. There's no authority that says that equitable compensation for breach of equitable duty of care can be awarded in a sum greater than the loss, nor obviously damages for breach of common law duty, nor damages for breach of statutory duty. There's no case that says anything like that. The difficulty with most of the cases one looks at, 19th century cases and otherwise, is that they are all cases where the amount of the loss is plainly exactly the same as the amount of the unlawful dividend. So there's no real issue. One doesn't get this issue arising at all. And my lords, it didn't arise either in the Bairstow case, but I'll come to that in a moment. The starting point, I submit, is the Target case, which was indeed a case about equitable compensation for breach of trust. And my lords, one can see that in tab 62.
Volume 7?
Volume 7, yes. And my lords, in this case, this case brought by solicitors who were holding some funds in trust, and what they had done wrong was that they paid the funds away before receiving the security involved. They then later received the security, and it turned out the security was worthless. The Court of Appeal held that the solicitors must just reimburse to the trust estate the full amount of the sums paid over, but wrongfully paid out, even though in fact that wasn't the loss, or might not have been the loss, because the security in any event was always going to be worthless. And so even if they had, as it were, paid when they should have paid, the same loss would have been sustained. And it was a summary judgment application, and certain facts were assumed in favour of the solicitors. But, my lords, the important passage, the first important passage begins on page 433 at E. Before dealing with these two lines of argument, it's desirable to say something about the approach to the principles under discussion. The argument before the Court of Appeal and your Lordships concentrated on the equitable rules establishing the extent and quantification of the compensation payable by a trustee who is in breach of trust. In my judgment, this approach is liable to lead to the wrong conclusions in the present case, because it ignores an earlier and crucial question, viz. Is the trustee who has committed a breach under any liability at all to the beneficiary complaining of the breach? There can be cases where, although there is an undoubted breach of trust, the trustee is under no liability to the beneficiary. For example, if a trustee commits a breach of trust with the actual absence of one beneficiary, that beneficiary has no right to complain, and an action for breach of trust brought by him would fail completely. Again, there may be cases where the breach gives rise to no right to compensation. Say, as often occurs, a trustee commits a judicial breach of trust by investing in an unauthorised investment, which proves to be very unprofitable. carping beneficiary can insist that the unauthorised investment be sold and the proceeds invested in authorised investments. But the trustee would be under no liability to pay compensation either to the trust fund or to the beneficiary, because the breach has caused no loss to the trust fund. Therefore, in each case, the first question to ask is, what are the rights of the beneficiary? Only if some relative right has been infringed is it necessary to consider the extent of the trustee's liability to compensate for loss. And then the next paragraph, Lord Brown-Wilkinson goes on to explain the basic right of the beneficiary to have the trust administered. And then C, the equitable rules of compensation for breach of trust have been largely developed in relation to such traditional trusts, where the only way in which the beneficiary's rights can be protected is to restore to the trust fund what ought to be there. In such a case, the basic rule is that a trustee in breach of trust must restore or pay to the trust estate either the assets which have been lost to the estate by reason of the breach or compensation for such loss. Courts of equity didn't award damages, but acting in personam ordered the defaulting trustee to restore the trust estate. If specific restitution of the trust property is not possible, then the liability of the trustee is to pay sufficient compensation to the trust estate to put it back to what it would have been had the breach not been committed. Even if the immediate cause of the loss is dishonesty and so on, the trustee is liable to make good the loss to the trust estate, if, but for the breach, such loss would not have occurred. Thus, the common law rules of remoteness of damage and causation do not apply. However, there does have to be some causal connection between the breach of trust and the loss to the trust estate, for which the compensation is recoverable, viz., the fact that the loss would not have occurred but for the breach. And also, that's the first passage. In other words, there's got to be some causation here. You look at questions of causation. Then, perhaps more importantly, at page 437b, and my lords, this would apply to a director who wrongly pays away a dividend. A trustee who wrongly pays away trust money, like a trustee who makes an unauthorised investment, commits a breach of trust and comes under an immediate duty to remedy such breach. If immediate proceedings are brought, the court will make an immediate order requiring restoration to the trust fund of the assets wrongly distributed, or in the case of an unauthorised investment, will order the sale of the unauthorised investment and payment of compensation for loss suffered. But the fact that there's an accrued cause of action as soon as the breach is committed does not mean, in my judgment, that the quantum of the compensation payable is ultimately fixed as at the date when the breach occurred. The quantum is fixed at the date of judgment, at which date, according to circumstances then pertaining, the compensation is assessed at the figure then necessary to put the trust estate or beneficiary back into the position it would have been in had there been no breach. I can see no justification for stopping the clock immediately in some cases, but not in others. To do so may, as in this case, lead to compensating the trust estate for a loss which, on the facts known at trial, it has never suffered. And my lords, I obviously rely on that. And finally, page 438, D, Lord Brown-Wilkinson extracts certain views from the judgment of Mr. Justice McClacken, which explains the difference between the assessment of damages at common law and the assessment of equitable compensation for breach of trust. While foreseeability of loss does not enter into the calculation of compensation for breach of fiduciary duty, liability is not unlimited. Just as restitution in specie is limited to the property under the trustee's control, so equitable compensation must be limited to loss flowing from the trustee's acts in relation to the interest he undertook to protect. And then, it's a quotation from Davison. A related question which must be addressed is the time of the assessment of the loss. In this area, tort and contract law have little help. The basis of the compensation in equity is the restoration of the actual value of the thing lost through the breach. As a result, the losses are to be assessed at the time of trial using the full benefit of hindsight. And in summary, compensation is equitable monetary remedy available when the equitable remedies of restitution of account are not available, and so on. We look at the plaintiff's actual loss.
And then his own passage at B on page 439.
Yes. In my view, it's good law, sorry.
Yes.
Equitable compensation is designed to achieve what the word compensation suggests. Now, my lords, in this case, there's no question, and assume against me for the moment, that Mr. Holland was actually in breach of fiduciary duty as opposed to equitable duty of care. He could be liable to account if he had paid himself the dividends. You would say, you must account for the profits received. You've actually received the money yourself. I want you to account for the loss. In that case, we're not in that case at all. No. So there's no question here of the fiduciary being ordered to provide an account of profits. So we are in the territory of equitable compensation. If we're in that territory, my lords, I submit we are in the territory, not of foreseeability, I accept that, if we're looking at looking at it as a question of breach of trust, but we are in the territory of looking at it as if you take into account all relevant questions of causation.
Well, would that be a convenient point at which to break? Now, how are we for timing? Because
I hope I can. I've really only got a couple of cases after this, and I don't want to spend much time on the other ones.
It's just so long as you give Mr. Green sufficient time to reply.
Yes.
Thank you very much. 2 o'clock.